Good morning, everyone. A kind request to everyone in the audience, please be seated. We will be commencing with the inaugural ceremony of the second edition of the NLIU-SBA Law Conclave in about 5 minutes. Thank you. Good morning, everyone. I please request everybody to be seated. The chief guest and all our dignitaries will be arriving soon. Greetings and a very good morning to our esteemed dignitaries, respected members of the bench and the bar, distinguished faculty, dedicated participants, and dear students. A warm and gracious morning to each one of you. I am Nitya Telang.
And I am Ashita Mathur.
Students at National Law Institute, University Bhopal. It is with profound privilege and quiet pride that we welcome you to the second edition of the NLIU-SBA Law Conclave, Bar, Bench, and Beyond, Imagining Law and Justice in the 21st Century. 1 year ago, this conclave began as a quiet conviction that the voices of tomorrow deserve a platform today. The first edition lit a small but steady lamp of dialogue, and now, with this second edition, we gather not merely to witness a flame, but to understand its direction and to ensure it illuminates the path ahead, not just for law students, but for the legal ecosystem itself. This conclave has evolved into something larger than an academic event. It is a rare and deliberate convergence of the bar, the bench, and the classroom, where experience meets inquiry, where judgment meets reflection, and where the law is not only interpreted, but also imagined anew. We are deeply humbled by the presence of our dignitaries who have joined us today, jurists who have shaped precedent, scholars who have challenged conviction, and practitioners who have lived the law in its most human dimensions. Let us begin this second edition with renewed purpose, mutual respect, and the quiet confidence that meaningful conversation is the first step towards meaningful change.
It is now our solemn privilege to introduce the distinguished dignitaries who have graced this occasion with their presence. We are deeply honored to have with us as our chief guest for the inaugural ceremony of the second edition, Honorable Mr. Justice Sanjay Karol. Today, we have the distinct honor of hosting Honorable Mr. Justice Sanjay Karol, Judge of the Supreme Court of India. Justice Karol practiced at Delhi and other high courts, served as Advocate General of Himachal Pradesh, and was designated Senior Advocate in 1999. He was elevated as a High Court judge in 2007, later became Chief Justice of the Tripura High Court and then the Patna High Court, before being elevated to the Supreme Court in 2023. His lordship's judgments reflected deep commitment to constitutional values and humane justice. We are honored to welcome our guest of honor for this ceremony, Honorable Shri Justice S.A. Dharmadikari, Chief Justice, Madras High Court. Today, we have the distinct pleasure of hosting Honorable Shri Justice S.A. Dharmadikari, Chief Justice of the Madras High Court. Justice Dharmadikari commenced his legal career in 1992 at the Madhya Pradesh High Court, later serving as standing counsel for the Union of India for over a decade. Sir, your presence here today is a source of immense inspiration. We are deeply honored by your guidance. We are also deeply honored to welcome Honorable Justice Mr. Pankaj Mittal, Judge of the Supreme Court of India, who shall be joining us virtually today as our distinguished guest for this inaugural ceremony. Justice Mittal was elevated to the Supreme Court in 2023 after serving as Chief Justice of the Jammu and Kashmir and Ladakh High Court and later of the Rajasthan High Court. Sir, your presence today is a source of immense inspiration for all of us, and we are deeply honored by your guidance. Today, we also have the distinct pleasure of hosting Honorable Mr. Justice Maralur Indrakumar Arun, Judge of the Karnataka High Court, as our distinguished guest. Justice Arun graduated from the National Law School of India, University, Bangalore in 1993. After practicing as an advocate, he was elevated as an additional judge of the Karnataka High Court on 7th January 2020 and became a permanent judge on 25th September 2021. Sir, your presence today is a source of immense inspiration. We are deeply honored by your guidance during this event.
Now, to introduce a most illustrious person in this college, a leader whose vision sees beyond administration into vision, values, and the shaping of character. We are deeply privileged to have with us our Vice Chancellor, Sir, Professor Dr. S. Surya Prakash, with over 3 decades in legal academia, Professor Surya Prakash has served as the founder of Vice Chancellor of MNLU Aurangabad and Vice Chancellor of DSNLU Vishakhapatnam. His scholarship spans jurisprudence, ADR, arbitration, labor laws, and health law, and he is a prolific author and mentor to countless young minds. Sir, we are truly honored to have you here today. Behind every thriving institution stands an administrator who transforms vision into reality and policies into action. We are honored to have with us our Registrar Sir, Mr. Vivek Bakshi. With a keen commitment to institutional excellence, Sir has been the steady force ensuring that governance meets purpose and that every student initiative finds the right support. Moving forward, as a gesture of our deepest respect and appreciation, we take this opportunity to extend a warm welcome to our esteemed dignitaries. We are delighted to present our distinguished guests with a floral welcome accompanied by a memento and a handmade shawl, representing the warmth of our welcome and the rich cultural heritage of Bhopal. I request our Honorable Vice Chancellor Sir, Professor Dr. S. Surya Prakash, to kindly extend this welcome to our Chief Guest, Honorable Mr. Justice Sanjay Karol. I now request our Vice Chancellor Sir to also welcome our guest of honor, Honorable Justice S.A. Dharmadikari. I also would like to request Registrar Sir to graciously welcome our distinguished guest, Honorable Justice M.I. Arun. I also call upon the President of the Student Bar Association, Mr. Priyanshu Gupta, to felicitate our Vice Chancellor, Sir. I would also request Mr. Priyanshu Gupta to also felicitate our Registrar, Sir. Can we please have a round of applause for our distinguished dais? As we commence the second edition of this conclave, we uphold the cherished tradition of the lighting of the ceremonial lamp, a flame that has stood through time as a silent witness to humanity's pursuit of wisdom, knowledge, and progress. May this light dispel the shadows of indifference and guide our deliberations over the next 2 days. I now respectfully invite all our esteemed dignitaries on the dais to kindly step forward for the lighting of the lamp.
शीतला सस्यश्यामला मातरं वन्दे मातरं शुभ्रज्योत्स्ना पुलकितयामिनी पुल्लकुसुमित द्रुमदलशोभिनी सुहासिनी सुमधुरभाषिणी सुखदां वरदां मातरं वन्दे मातरं वन्दे मातरम्
I now kindly request our Honorable Vice-Chancellor, Sir, Professor Dr. S. Surya Prakash, whose profound insights have consistently inspired the NLIU community, to please deliver the welcome address.
Chief guest for the today's program, Honorable Justice Sri Sanjay Karolji, Judge Supreme Court of India. The guest of honor, Honorable Justice S.A. Dharmadikari ji, Chief Justice, High Court of Madras. Honorable Justice A.I. Arun ji, the distinguished guest for today's inaugural session of the Students' Conclave. Honorable Justice Sri Pankaj Mittal ji, who is going to address us online. Judge Supreme Court of India, and also the Honorable Visitor of this university. Learned faculty, advocates, students of NLIU, and also students coming from different colleges and universities. And dear SBA, President, Secretary, the executive body, and all other members, a very, very good morning to all of you. So last year, we started this SBA Law Conclave to discuss the latest developments in law by inviting distinguished professors, judges, and the law professors. And this time, we had very intellectual, inspiring gathering among the audience, and also on the dais, we have the greatest judges. And we are fortunate to have this, that this auditorium has been named after one of the tallest figures of the Indian judiciary, Honorable Justice J.S. Verma. So the moment we take his name, because our generation is very fortunate that we worked, and as he happened to be the founder, the first founding stone was laid by Honorable Justice J.S. Verma, and he used to visit our university whenever we invite him, and he used to mix up with the faculty, as he is also an academician. And also, the person behind this entire program, guiding and organizing, Mr. Vivek Bakshi, the registrar, and my dear student friends. So, first of all, already our chief guest was introduced, and there are so many judges who have seen in the Supreme Court and in the High Court, and where the most complicated thing may be said in a most simplest way, and even a simplest issue may be projected in hundreds of pages. Recently, I have gone through the judgment of Honorable Justice Karol Saab and Sanjay Karol ji. I think it was delivered on 7th April this year only. It is a matter relating to migration of reservations. And it's a case coming from West Bengal State Electricity Transport Company Limited versus Deepen Biswas. A candidate has applied who has poor visibility, and the post was reserved for unreserved general category, but with a rider that who has the visibility defect, that is physically handicapped. And there was a competition, and there were also other candidates from SC, ST, OBC also, who are visually impaired and who are even more serious cases. So that when the matter has come before the Honorable Court, Honorable Justice has decided the matter. It's what is somebody wants to learn about what is a vertical reservation, horizontal reservation, and how the reservation will migrate from one to other. It's a little bit complicated, but how the judicial mind has handled it. When I was reading this judgment, I was reminded of my student days, a judgment of D.N. Banerjee versus P.R. Mukherjee, also popularly known as Baj Municipality case. Honorable Justice Mukherjee has, that's also a matter relating to the definition of industry, hardly in 10 pages, around 10 pages. And later on, we know that the definition of industry, Honorable Justice Krishna Iyer has written 300 pages. So, what I would like to say is that brevity, simplicity, sir is not only simple in his daily life, and nowhere, yesterday I went to see him, to receive him, nowhere he has shown that he is of course he is judge of the Supreme Court of India. He is as humble, as gentle as maybe Honorable Justice J.S. Verma. Sir, I also had very good rapport with him. And justice is not only the judicial acumen of Honorable Justice Karolji, and he is very deeply socially conscious. And normally we read many articles, many books with the people of India. And sir has concluded one of his judgments with the people of India. So the poetic and also the social consciousness and the pain, it is a matter relating to the dowry death, Shankar versus State of Rajasthan. This was also very, very latest. And I'm not going to read the legal issues and other things. But how a judge has responded, things are happening, crime is happening, but still not only deciding the matter, but also expressing his views. Of course, sir has quoted to quote, yes, despite the sustained intervention from different branches of government, this matter relating to the dowry death, empirical data shows that all is not well. It presents sobering picture indeed. As per the National Crime Records Bureau, more than 4.48 lakh crimes against the woman were recorded in 2023. Dowry-related violence to claim 6,000 lives annually. So this is still continuing. So, Sir has conveyed the message that ever since the mankind started its journey, man was never kind to woman, and atrocities against women are happening. So, crux of this judgment, how Sir has reflected, his amplified his social consciousness, I would like to quote, "The coexistence of progress and violence signals to a paradox. Legal and economic advancements are visible on a macro level, but patriarchy still permeates every day. Dowry is outlawed and has been decades, but social legitimacy that sustains it is yet to be dismantled. Welfare schemes can incentivize education, but cannot alter long-held beliefs about women's role within marriage and family. As a result, practices such as domestic abuse or extreme acts like burning a wife, such as in this case, persist not as aberration, but as indications of disease-afflicted social order." So, next lines, Honorable Justice tried to make the people aware of what's happening, reminds the civility among the society. To quote, "After decades of laws, schemes, reforms, and judicial recognition of equality across workplaces, homes, personal relationships, and even armed forces, why does the control over women's bodies, choices, and lives still persist so deeply within society? Perhaps, the answer lies only with we the people of India." So how succinctly has shown the way, made the nation to think how we are treating our women. I also prepared for other judgments of Honorable Justice Dharmadikari ji and Arun ji, but due to paucity of time, I am concluding. Sir, once again, for the distinguished Honorable Judges, thank you, sir, very much. On behalf of me, on behalf of SBA, for sparing your valuable time to visit and to grace this occasion. Thank you very much. Jai Hind.
I now invite the President of the Student Bar Association, NLIU Bhopal, Mr. Priyanshu Gupta, whose dedication and vision have been instrumental in shaping the second edition of the conclave, to kindly share the purpose and journey of the SBA conclave.
Good morning, everyone. It is my profound privilege as the President of the Student Bar Association, NLIU Bhopal, to welcome you all to the second NLIU-SBA Law Conclave. We are deeply honored by the gracious presence of Honorable Mr. Justice Sanjay Karol, Judge, Supreme Court of India, Honorable Justice S.A. Dharmadikari, Chief Justice, Madras High Court, and Honorable Mr. Justice M.I. Arun, Judge of the High Court of Karnataka. Your presence today is not just an honor for our institution, but a moment of inspiration for every student seated here. I also extend a warm welcome to all the esteemed dignitaries, respected faculty members, and my fellow students who form the backbone of this vibrant academic community. The NLIU-SBA Law Conclave was conceived as more than just an academic gathering. It is a platform where ideas meet experience, where questions meet wisdom, and where the future of law engages with its present realities. Guided by our motto, the bar, bench, beyond, we aim to bridge conversation across institution, professions, and perspective. This year's theme, Reimagining Law and Justice, Challenges, Accountability, and Reform, is both timely and necessary. We find ourselves at a critical juncture where the law is not merely to be interpreted, but it is also to be introspected. And within this, we have tried to focus on 4 pressing issues, yet extremely interesting. First, strengthening the arbitration framework in India, especially at a time when India is positioning itself as a global hub for arbitration. Second, strengthening the grassroots of the Indian judiciary and how we can realistically blend access to justice with technology in the 21st century, because justice is only meaningful if it is accessible. Third, something very close to us as students, moving beyond degrees and asking whether our academic structure are really building industry-ready lawyers. This conclave will see deliberation on these issues. And lastly, a slightly deeper and more reflective question, moving beyond the colonial hangover, the examining the extent to which our legal system continues to be shaped by westernization and whether it needs to evolve in a way that is more rooted in our realities. Today's conclave brings together voices from bench and the bar, whose experience and insight will undoubtedly enrich our understanding of these complex issues. It is through such interaction that we begin to appreciate not just what law is, but what it ought to be. On behalf of the Student Bar Association, I would like to express our sincere gratitude to all those who have contributed to making this conclave possible. Our administration, respected Vice Chancellor Sir, Registrar Sir, our faculty advisor, Professor Dr. Raka Arya, organizing team, volunteers. Your dedication and effort are the foundation upon which this event stands. As we commence this conclave, I encourage everyone to engage actively, listen thoughtfully, and question meaningfully. With that, I once again welcome you all and look forward to an insightful and enriching conclave. Thank you. Jai Hind, Jai Bharat.
Thank you for your address. We are deeply honored to have with us Honorable Mr. Justice M.I. Arun, Judge of the High Court of Karnataka, as our distinguished guest for this inaugural ceremony. Your Lordship's profound legal acumen and steadfast dedication to justice have been a source of inspiration for the entire legal community. I respectfully invite Your Lordship to kindly address the gathering.
Law is full of surprises. I was not scheduled to be on the stage today. I was definitely not scheduled to be addressing you people over here. Even when I sat over here, I told them I'll not be speaking. You can skip my address because I was not informed about it. Anyway, they've asked me to share a few thoughts. I'll try to share a few thoughts because I was not really ready to speak. Sir, Mr. Justice Sanjay Karol, Judge, Supreme Court of India, Sir Justice S.A. Dharmadikari ji, Chief Justice, Madras High Court, distinguished guests on the dais, dear students, ladies and gentlemen. Reimagining law and justice in the 21st century, challenges, accountability, and reforms. As you all know, an advocate need not know the law. He needs to know where to find the law and how to interpret it. Number one. Then number two, as just now while speaking, one of your students said, we'll also try to discover what law is ought to be. Law visualizes an ideal situation. Rule of law is most important. What sets apart a developed nation vis-a-vis a developing nation like our country is adherence to rule of law, number one. And of course, cleanliness. These are the two things that sets us apart. Now, with regard to this rule of law, what the law has to be, how it is functioning, what are the amendments that are required, how do we solve the social issues by making necessary amendments. You're also aware, law means it's an instrument of social change. How do we go about? It is these types of get-together which helps us think over, ponder, and make necessary suggestions. A simple example I would like to give. Today, in India, bulk of the litigation pertains to property, and bulk of it is because we are not able to find out the actual genealogical tree of the person who is selling the property. If we have a small amendment as to the person whose name is not reflected in the revenue records, will not have a right on the purchaser, but only against the vendor of the property, it will go to a long extent. So it is this way we require amendments to laws, and it is these types of seminars and programs which actually helps us come up with these aspects. Now, as you all know, dowry, sati, untouchability, so many other aspects which were social evils have been addressed by law and have been cured. Now, this, I think, this particular today's and tomorrow's program pertains to revisiting and reforming the Arbitration Act 1996. Arbitration and Conciliation Act, in my opinion, is an enactment enacted for the welfare of the persons investing in India, the Western powers, rather than catering to the Indian masses itself. So in the light of that, is it relevant today, or should we emphasize more on Commercial Courts Act CPC rather than giving up on Arbitration and Conciliation Act altogether, is also an issue to be pondered about. I'm not giving any opinion, I'm just stating that what needs to be pondered about. Then, beyond colonial hangovers, rethinking and reforming the Western influence on India's legal system. See, what is law? It is nothing but bundle of principles. What is this rule of law? What is the purpose of law? We require sets of rules and regulations which helps a person to develop his personality. Those rights are inalienable rights. That we consider it as fundamental rights. Then you have certain rules and regulations which are required for peaceful coexistence of fellow citizens in the society. Your liberty stops where the other man's nose begins. You can swing your stick and walk, but your liberty stops where the other man's nose begins. So law is nothing but that. Now, when we are talking about Western influence, when it comes to principles, our own Vedas, Upanishads, Jain Agamas, Buddhist preachings, our own philosophies contain these principles, which has been unfortunately unexplored so far. I would say that when it comes to humanity, yes, rule of law, the developed nations are better. When it comes to humanity, still we are much far ahead. We are that much more humane, we are that much more peace-loving, and we want to help each other. That being the case, we need to probably re-examine the principles on which Indian society is based upon, and we need to highlight that. To that extent, this becomes very important. Anyway, there are other two sessions also which do not find a mention over here, and I am part of one of those sessions. Anyway, I think I thank the organizers once again for inviting me and giving me an opportunity to share a few thoughts with you. Thank you.
I thank your Lordship for his inspiring words. We are deeply honored to have with us Honorable Mr. Justice S.A. Dharmadikari, Chief Justice of the Madras High Court, as our guest of honor for this inaugural ceremony. Your Lordship's distinguished judicial career and unwavering commitment to the rule of law have earned the deepest respect of the legal fraternity. I respectfully invite your Lordship to kindly address the gathering.
Honorable Mr. Justice Sanjay Karol, Judge, Supreme Court of India. Honorable Justice Mr. Pankaj Mittal, Judge, Supreme Court of India, who is joining us virtually today. Justice M.I. Arun, Judge, Karnataka High Court. Professor Dr. Surya Prakash, Vice Chancellor, National Law Institute, University Bhopal. Professor Dr. Raya Arya, Dean, National Law Institute, University Bhopal. Distinguished members of the faculty, today we have with us a senior advocate from Jabalpur, Aditya Sanghi, then Siddharth Gupta and Sankalp Kochar, and other distinguished members of the faculty, esteemed legal luminaries, guests, and the bright young legal minds of NLIU Bhopal. A very good morning to all of you. At the outset, I would like to confess that this is my first official visit to Bhopal, City of Lakes, since assuming the office of the Chief Justice of the Madras High Court. To return to one's home state is always a moment of reflection. But to do so in this capacity is deeply moving. The state is a repository of memories, as is the soil that nurtured my early aspirations. When I received the invitation for the second National Law Institute University Student Bar Association Law Conclave 2026 from the Vice Chancellor, I was invited as a speaker in the fourth session scheduled tomorrow, and also to be a part of the valedictory. However, when I learned that His Lordship Justice Sanjay Karolji is gracing the inaugural ceremony, I opted to partake in the inaugural ceremony as well. To have His Lordship preside over this inaugural ceremony is a profound privilege for this institution, as we look to him as a lighthouse of legal erudition and unwavering integrity. His judgments have consistently served as a living treatise on balancing the letter of the law with the spirit of equity. The National Law Institute University has been established in 1997 and served as a crucible for legal excellence. NLIU Bhopal was born out of a necessity to bridge the gap between traditional legal pedagogy, and the modern needs of the globalized world. The theme of this conclave, Reimagining Law and Justice in the 21st Century, Challenges, Accountability and Reforms, is not merely academic. To reimagine does not mean to abandon our foundational values of liberty, equality, and fraternity. Rather, it means translating the 1950s constitutional promise into the language of 2026. We have recently seen the overhaul of our criminal laws focusing on Nyaya, justice, as in Bharatiya Nyaya Sanhita, rather than mere dand, punishment, as in Bharatiya Dand Sanhita. We must move from litigation-centric justice to resolution-centric justice. Our jurisprudence must evolve to recognize that the environment is not a resource to be exploited, but a trust to be protected. The judiciary itself must be the first to embrace transparency. Our move towards digital case management is not just a technological upgrade, it is a moral commitment to being seen doing justice. After assuming the office of the Chief Justice of Madras High Court, my foremost area of concern and attention is employing technology efficiently for making justice accessible and available to every doorstep at a minimal cost with maximum interaction. Technology is the way forward in the 21st century if you want to make justice cheap and accessible to the litigant for whom this whole system and institution is designed to serve. To the students who are present here today, I would like to say that you are the architects of the future legal system. The 21st century does not need walking encyclopedias of case laws, as we have database for that. It needs lawyers who understand that behind every file number is a human life, and behind every delay is diminishing of a soul. Bhopal, a city that has witnessed one of the world's greatest industrial tragedies, let that history fuel your passion for a system that is proactive, not just reactive. As I conclude, I remind you that the law is not a static monument, it is a living, breathing organism. If it does not grow, it decays. Let this conclave be the spark that ignites new ideas for a more equitable, accountable, and modern Indian judiciary. Thank you. Jai Hind.
I thank your Lordship for his inspiring words. We now have the privilege of connecting virtually with Honorable Mr. Justice Pankaj Mittal, Judge, Supreme Court of India. Your Lordship's distinguished career and profound understanding of constitutional morality make this virtual presence deeply valued. I respectfully invite your Lordship to deliver the virtual inaugural address for this second edition.
महोदय, फैकल्टी मेंबर्स, प्रिय छात्र छात्राओं तथा सभी सम्मानित अतिथिगण, आप सभी को मेरा हृदयपूर्वक प्रणाम। मुझे अत्यंत प्रसन्नता है कि नेशनल लॉ इंस्टीट्यूट यूनिवर्सिटी भोपाल द्वारा आयोजित द्वितीय स्टूडेंट बार एसोसिएशन लॉ कॉन्क्लेव 2026 के अवसर पर मुझे किसी न किसी प्रकार से आपसे जुड़ने का अवसर मिल रहा है। इस महत्वपूर्ण आयोजन का हिस्सा बनना मेरे लिए गर्व और संतोष का विषय है। सबसे पहले मैं स्टूडेंट बार एसोसिएशन के सभी पदाधिकारियों और छात्रों को इस उत्कृष्ट पहल के लिए हार्दिक बधाई देता हूँ। इस अवसर के आयोजन यह दर्शाता है कि हमारे छात्र केवल पढ़ाई तक सीमित नहीं हैं, बल्कि वे समाज व विधि व्यवस्थाओं से जुड़े महत्वपूर्ण प्रश्नों पर गंभीरता से विचार करने की क्षमता रखते हैं। इस वर्ष की थीम रीइमेजिनिंग लॉ एंड जस्टिस इन द 21st सेंचुरी, चैलेंजेस, अकाउंटेबिलिटी एंड रिफॉर्म्स वास्तव में हमारे समय की सबसे बड़ी ज़रूरतों को सामने रखती हैं। आज हम एक ऐसे दौर में हैं जहां परिवर्तन बहुत तेजी से हो रहा है। तकनीक का विस्तार, वैश्विक संबंधों में बदलाव और समाज की बढ़ती अपेक्षाएं, इन सब में कानून और न्याय की पारंपरिक सोच को चुनौती दी है। आज न्याय केवल निर्णय देने तक सीमित नहीं है, बल्कि यह सुनिश्चित करना भी उतना ही जरूरी है कि न्याय समय पे मिले, सभी को सुलभ हो और उस पर लोगों का विश्वास बना रहे। इस संदर्भ में मुझे सम्राट जहांगीर की न्याय की जंजीर अदालत की याद आती है। उस युग में वह जंजीर जवाबदेही और सुलभ न्याय का प्रतीक थी, जिसे कोई भी पीड़ित सीधे खींचकर राजा से न्याय मांग कर सकता था। आज की 21वीं सदी में जब हम रीइमेजिनिंग लॉ एंड जस्टिस की बात करते हैं, तो हमें भौतिक जंजीरों का नहीं, बल्कि ऐसे डिजिटल और पारदर्शी व्यवस्था की ज़रूरत है जहां न्याय आम आदमी के लिए उतना ही सुलभ हो। हमारा लक्ष्य यह होना चाहिए कि तकनीक और सुधार के माध्यम से न्याय केवल अदालतों तक सीमित ना रहे, बल्कि नागरिक के द्वार तक पहुँचे। न्याय चला निर्धन से मिलने, या फिर घर घर न्याय। न्यायपालिका, विधायिका और कार्यपालिका तीनों के बीच में संतुलन और जवाबदेही इस प्रक्रिया का अत्यंत आवश्यक अंग है। सस्ता और सुलभ न्याय के लिए हमें मध्यस्थता और मीडिएशन और आर्बिट्रेशन की ओर अधिक बढ़ावा देने की आवश्यकता है। यदि हम चाहते हैं कि भारत एक वैश्विक स्तर पर विश्वसनीय विवाद समाधान केंद्र बने, तो हमें अपने कानूनों की प्रक्रिया को और अधिक सरल, पारदर्शी और प्रभावी बनाना होगा। वैश्विक स्तर पर हम सभी देख रहे हैं कि दुनिया कई चुनौतियों का सामना कर रहा है, चाहे वह राजनीतिक अस्थिरता हो, आर्थिक असमानता हो या अंतर्राष्ट्रीय संबंधों में बदलाव। ऐसे समय में कानून की भूमिका केवल व्यवस्था बनाए रखने की नहीं, बल्कि न्याय और संतुलन स्थापित करने की है। प्रिय विद्यार्थियों, आज आप सब इस देश की न्याय व्यवस्था के भविष्य हैं। आप में से कोई लोग आगे चलकर न्यायाधीश, अधिवक्ता, विधि विशेषज्ञ और नीति निर्माता बनेंगे। इसलिए ये आवश्यक है कि आप कानून को केवल एक पेशे के रूप में न देखें, बल्कि इसे समाज में सकारात्मक बदलाव लाने के एक साधन के रूप में अपनाएं। कानून की पढ़ाई केवल धाराओं और प्रावधानों को समझने तक सीमित नहीं होनी चाहिए। यह आपको सोचने की क्षमता देती है और सही और गलत के बीच अंतर समझने की समझ देती है, और सबसे महत्वपूर्ण, यह आपको न्याय के प्रति संवेदनशील बनाती है। हमारे देश की परंपरा में कहा गया है, न्याय ही समाज की सबसे बड़ी शक्ति है। यदि न्याय मजबूत होगा तो समाज भी मजबूत होगा। मुझे विश्वास है कि इस कॉन्क्लेव के माध्यम से होने वाली चर्चाएं, विचार विमर्श और संवाद आप सभी को नई दिशा देंगे। यह मंच आपको न केवल सीखने का अवसर देगा, बल्कि अपने विचार रखने में उन्हें परखने का भी अवसर देगा। मैं आप सभी से आग्रह करता हूं कि आप इन 2 दिनों का पूरा लाभ उठाएं, खुलकर चर्चा करें, प्रश्न पूछें और नए विचारों को अपनाने के लिए तैयार रहें। यही प्रक्रिया आपको एक बेहतर विधि पेशेवर और एक जिम्मेदार नागरिक बनाएगी। अंत में मैं एक बार फिर NLIU भोपाल और स्टूडेंट बार एसोसिएशन को इस सफल आयोजन के लिए हार्दिक शुभकामनाएं देता हूं। मुझे पूर्ण विश्वास है कि ये कॉन्क्लेव न केवल ज्ञानवर्धक होगा, बल्कि आप सभी के लिए प्रेरणादायक भी सिद्ध होगा। आप सभी के उज्जवल भविष्य के लिए मेरी हार्दिक शुभकामनाएं। धन्यवाद। जयति जयति जय मम भारतम।
I humbly thank His Lordship for addressing us virtually. And now we arrive at the most anticipated moment of this inaugural ceremony, I have the highest honor of inviting Honorable Mr. Justice Sanjay Karol, Judge, Supreme Court of India, our esteemed chief guest, whose judgments have consistently reflected a deep commitment to justice, equity, and the human dimension of law. Your Lordship, please grace the podium to address the gathering.
A very good morning to everyone here. My dear students to begin with, past and present who are here, or are with you through virtual mode. My elder brother, Honorable Justice Pankaj Mittal, Chief Justice Dharmadikari ji, Justice Arun, our Guru, Professor Surya Prakash ji, Shri Bakshi, our Guru who are there, sitting there in the audience, pranam to all of you. Other faculty members of this great institution. We have Mr. Aditya Singla and Mr. Jain Mehta. Also, we have with us Siddharth and Ishan, who are alumni of this great institution. Sorry, gentlemen, I am forgetting your name, Sankalp. It is indeed a great moment for me because I am reliving my days of studentship in Simla University, Himachal Pradesh University, Simla. You are very fortunate that you have alumni like Mr. Siddharth and others who have taken this initiative of bringing you all together under this single roof, whose stone was laid down by a stalwart, a very tall figure in the Indian justice delivery system, Honorable Justice Verma. I did not deliberately use the word late because he continues to live with us in our thoughts, in our actions. I do remember having appeared before him. And he is one person whom I emulate. And I often tell my law clerks and the interns who come to work with me that you have to live the Constitution every day. It doesn't make any sense any longer to be a jurist if you are not able to translate justice in the language and the thought of the litigant who is before us. You are very fortunate today that Justice Arun is here. I was just asking him whether he has a similar association there of the alumni or not. But surely he tells me that there is one. But definitely Siddharth, I will say, and also Mr. Gupta, who's now heading, is the president of the students' body here, and in times to come you will give great competition to Bangalore NLU. I wish you all the best. I prepared a written script also. I'll read that. If you ever watched Panchayat, you might remember how Abhishek Tripathi walks into the village office expecting structure, efficiency and clear systems, only to find himself navigating files, delays, and a reality that no textbook really prepared him for. Students, I'm narrating all this for you because in times to come, be it in 6 months, be it 1 year or 2 years, you're going to face what I'm going to tell you today. You may have seen Mamla Legal Hai. You would know that for many people, the legal system is not just about rights and remedies, but also about confusion, long waits, and trying to understand what is going on in the first place. It is funny when we watch it on screen, but it is familiar. Because somewhere between the idle version of law that we study and the lived reality of how it works, there is a gap. And the gap is exactly where some of the most important questions about justice begin. And that brings me to what I want to talk about today. Reimagining law and justice in the 21st century, its challenges, accountability, and the reforms it demands. Surely, the next 2 days, you'll discuss a whole lot of things. But I just want to also highlight how times have changed and how the tools have taken over our minds, if at all. We often say that law is a mirror of society. But today, that mirror feels like it is constantly shifting. The real question is not whether law reflects society, but whether it is willing to reshape it. AI is a very powerful, and there is no denying that it is bound to stay. It can make systems faster, more efficient, and more accessible. It can help reduce backlogs and support decisions making. But at the same time, it brings a quick risk. Because if the systems we build are not fair, they can reinforce the very biases we are trying to eliminate. And that is where Black Mirror stops feeling like fiction again. If justice becomes data-driven without being value-driven, we may end up with a system that works definitely efficiently but not fairly. So in my considered view, strengthening the grassroots of the Indian judiciary and blending access justice with technology is the need of the hour. I may also add this, that now we have become an open society. But is it that at all levels openness is accepted? Illustratively, we are seeing greater recognition of LGBTQ persons. We are talking more seriously about inclusion of persons with disabilities. When will this translate from talk to deliberate action is something which needs to be seen. And where do we stand in this era of transformative constitutionalism? is what we have to ask ourselves, because it becomes very, very important. The idea that our Constitution is not just a document that preserves what exists, but one that pushes us toward what should exist. We are serious about reimagining justice. We cannot stop here. We must turn to another crucial issue that is Conclave's places at the forefront: how we prepare our future lawyers. Today, more and more students are choosing law as the first choice, and that is a good thing. But 26 odd national schools in India, have the students who have passed out from that institutions, prestigious institutions, have they fulfilled the aspirations of those who had set up these institutions? Is something which we have to ask ourselves. Honorable Justice Mittal said that we have to be responsible citizens of this country. Honorable Justice Dharmadikari and Honorable Justice Arun mentioned that we are here to serve the people of India. And therefore, this profession, noble, is totally distinct and different from other vocations or professions. Children, you would have seen on Netflix the Suits. But in reality, when it comes to the justice delivery system in India, things are totally different at ground level. Pardon me if I transgress in saying that large number of students, products of these prestigious institutions, are aspiring to become lawyers as we see in Suits, and not lawyers as ought to be in Mamla legal hair. The heart and soul of the Constitution for us lawyers, for us, each one of us who are students of law, is to see that we transform the lives of the 140 crore Indians, regardless of their stature, their position, their power, economic, social, or otherwise. We have to see how best we can touch lives of each one of our citizens and make them, in their own language, understand what Constitution is and what constitutionalism is all about. I would also say this, that there are various issues which your body and the students can highlight. The Bhopal gas tragedy only reminds me that there are several such tragedies of climate change which are there or which need to be taken care of. The water bodies of Bhopal are drying up. Students take this as an opportunity of having a proactive role. I was told by your alumni that the place where this institution has come up, one would feel scared to travel alone during the day. This forest of foliage, flora and fauna, has been converted to a jungle of concrete. Can we not think how best we can preserve and protect our one judgment recently delivered. Friends, I recollect one incident. I had joined the office of the Advocate General in Himachal Pradesh. So Mr. Anant Kumar, perhaps, who comes from your state, Justice Arun, he was the aviation minister. A good friend, I went to meet him in his office. And his office was his secretary's office was very, very plush. So I asked him that normally, good old days, 98, 99, you did not see multinationals or offices of multinational companies. So I asked him that, I in fact complimented him. It's a great office. So he told me, sir, सरकार में तो ऐसा ही चलता, मैंने ये किसी से बनवाया है. It occurred to me that if the minister is not Sarkar, then who is the Sarkar? And then I realized that each one of us who are involved in public service, in the administration of justice or the government, are the Sarkar, be it the Chief Minister, the Chief Justice, or Class 4 employee. And that thought ingrained upon me, and I've continued with that thought, that we have to take up this responsibility of serving the people. I must also share one example with you students. I was there in Bihar for 3.5 years. I narrate this, those who have heard me earlier would find me to be repetitive. But I say this, that constitutionalism and constitution is not an abstract. It is to be, as I said, lived every day. I extensively traveled in Bihar, met with a lot of people of different levels. And Bihar taught me one thing, that, and I'll say this, I say it everywhere, that चौराहे पे जो खड़ा एक पुलिस कांस्टेबल है, that constable who's standing on the road, उसकी सीटी और लाठी में संविधान की आवाज़ है. So you have to live the Constitution, you have to respect that man, understand what his duty, obligation, difficulties are. Mr. Gupta, the president of the association, mentioned what is justice. How is it different than delivering justice? I would only say this, that this takes me back to a movie. I'm forgetting the name of the movie, but the famous dialogue of that movie was that कानून अंधा हो सकता है, जज नहीं. And therefore we have to, as a union, with only one aim in mind. We have to read the Constitution, understand the Constitution, live the Constitution, and make people understand what Constitution is all about. Be it at a marketplace, be it in a student's hostel, be it at the campus, be it at your home. Part 3, Part 4, Part 4A of the Constitution is something which must read as our holy scripture every day. Children, I must also tell you this. In fact, I request the Honorable Vice Chancellor that whenever you desire in future, till August I am there serving the nation in this capacity, or thereafter, my services are always available for your institution. I must also share this, sir. In fact, Ishan helped me, who's one of your alumni and is with me at this point in time, helped me because every day we stand to learn from each other. And he guided me, I'm using that word, guided me, that as a judge, you're duty bound to write judgments. There's no doubt about it. And by the way, I must also acknowledge here that it was Siddharth who put me on to Ishan. So Ishan told me, sir, there is something else which you have to think about when writing the judgments. And what we have done is this, we must share this with you. And I implore upon you, each one of the students here, my doors of my office are open. Till date, in the last 3 years, more than 250 students from different colleges of India, law universities, have done internship in my office. You must spread your wings, do judicial internship whenever you get an opportunity. And how I have been benefited, I must share this with students, that you have given me an insight of understanding what we, the people of India, are. And you have given me ideas, and your energy is something which I have absorbed, because you transmit so much of exuberance, energy, thought, modern thought, that I have implemented in the last 3 years in the Supreme Court. I wish you well, children. I would be always accessible to you. I would also wish well to the members of this body, and look forward for further interaction with you at different levels. Jai Hind. Thank you.
I thank your Lordship for your highly motivating and gracious words. We would now also like to honor those with us in the gathering whose lustrous presence must be marked today. I would like to request our chief guest, Honorable Mr. Justice Sanjay Karol, to honor Mr. Aditya Sanghi, Senior Advocate, Madhya Pradesh High Court. We would also like to recognize the leader who oversaw the genesis of this event last year, Mr. Yashpal Jhakar, former President, Student Bar Association. Mr. Yashpal Jhakar, former President of the Student Bar Association. Thank you. It is now my privilege to invite you to a special moment in our inaugural ceremony, the unveiling of the annual newsletter of the National Law Institute University, OJAS. The word OJAS in Sanskrit refers to the essence of vitality, vigor, and splendor. It perfectly captures the spirit of this publication, which has consistently chronicled the vibrant life of our institution. The latest edition of OJAS encapsulates the latest developments, achievements, and endeavors within our esteemed university, acting as a chronicle of our collective journey. We are to carry this legacy forward, capturing the milestones of the past year, from the moving victories we celebrated at Kritagya to the intellectual energy of this very conclave. I now request the first copies of OJAS to be presented to our distinguished guests for unveiling. May this publication serve as a testament to our unwavering spirit of legal inquiry and excellence. As we move forward in this inaugural ceremony, we arrive at a moment of symbolic significance, the official release of the SBA Conclave logo for the second edition. A logo is not merely an emblem. It is a quiet statement of identity, a visual commitment to the values that this conclave seeks to uphold. I respectfully invite our chief guest, Honorable Mr. Justice Sanjay Karol, Judge, Supreme Court of India, to unveil the logo. And also invite the guest of honor, Honorable Mr. Justice S.A. Dharmadikari, distinguished guest, Honorable Mr. Justice M.I. Arun, Judge, High Court of Karnataka, along with our Vice Chancellor, Sir, Professor Dr. S. Surya Prakash, along with our Dean Student Welfare, Professor Dr. Raka Arya, and the President of the Student Bar Association, Mr. Priyanshu Gupta, to join our dignitaries on stage to kindly unveil a montage of how the logo came to be. May this mark become a lasting reminder of the conversations begun here and the aspirations we carry forward.
As we draw the inaugural ceremony to a close, it is only fitting that we pause to express our gratitude for every word of wisdom shared, for every moment of grace bestowed, and for every effort that has made this gathering possible. I now invite the Secretary of the Student Bar Association, NLIU Bhopal, Mr. Dharmadikari, to kindly deliver the vote of thanks on behalf of the university.
Good morning, everyone. On behalf of Student Bar Association of National Law Institute, University Bhopal, it is my privilege to propose vote of thanks for this inaugural session of 2nd NLIU-SBA Law Conclave. At the outset, I extend our deepest gratitude to our esteemed chief guest, Honorable Mr. Justice Sanjay Karol, Judge Supreme Court of India, our distinguished guest, Honorable Mr. Justice Pankaj Mittal, Judge Supreme Court of India, who joined us virtually, and our distinguished guest, Honorable Mr. Justice S.A. Dharmadikari, and our distinguished guest, Honorable Mr. Justice M.I. Arun, Judge of the Karnataka High Court, along with the distinguished member of Bar, Bench, and Academia, for gracing this occasion with their presence. Your insightful address have not only set the tone for this conclave, but has also enriched our understanding of evolving legal landscape. I would also like to express our sincere gratitude to Honorable Vice Chancellor, Professor Dr. S. Surya Prakash, whose constant encouragement and visionary leadership continues to inspire initiatives such as this conclave. I would also like to extend our heartfelt gratitude to Registrar Mr. Vivek Bakshi for his steadfast administrative support and guidance, which has been instrumental in a smooth organization of this event. We are equally grateful to Dean Student Welfare and Faculty Advisor, Professor Dr. Rakarya, for her unwavering guidance and continuous support. Our heartfelt appreciation goes to all distinguished speakers and guests who have taken out time out of their demanding schedules to be part of this platform. Your participation truly embodies the spirit of dialogue and collaboration that this conclave seeks to promote. I would also like to acknowledge the tireless efforts of entire organizing committee and the entire Student Bar Association team, whose dedication and commitment have made this event possible. Finally, we extend our sincere thanks to all the participants and the attendees for part of this intellectual journey. Your presence adds immense value and meaning to this endeavor. As highlighted in the program, this conclave aims to foster meaningful discussion on contemporary legal challenges and reforms, and we hope that the sessions ahead will continue to inspire thought, dialogue, and innovation. With this, I once again thank everyone for their presence, valuable contribution, and I wish you all a highly engaging and enriching conclave ahead. Thank you. Jai Hind, Jai Bharat.
Thank you, Mr. Nadi. I would now request everyone to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मांगे। गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता।
I would now request our dignitaries to proceed to the visitors' room for a short reprieve, while I ask everyone in the audience to please remain seated. We will shortly begin with the first panel discussion of the day. Thank you.
I request everyone to kindly be seated. I request everyone to please be seated. We will be beginning with the first panel sessions shortly. A very good morning to our esteemed dignitaries, respected faculty members, and discerning participants present here. It is my honor to welcome you to the first discussion session of the second edition of the NLIU-SBA Law Conclave. Allow me to first introduce the distinguished panel for this session. We have the immense pleasure of welcoming Honorable Mr. Justice Sanjay Karol, who is a distinguished judge of the Supreme Court of India and an eminent jurist whose career stands as a testament to integrity, constitutional fidelity, and an unwavering commitment to justice. He practiced at Delhi and other high courts. He is appointed Advocate General of Himachal Pradesh in 1998, served till 2003, and was designated Senior Advocate by the full court in 1999. He was elevated as a judge of the High Court on 8th March 2007. Serving for 11 and a half years, including over a year as acting Chief Justice. He was Patron-in-Chief of Himachal Pradesh Legal Services Authority and Chancellor of Himachal Pradesh National Law University. He became Chief Justice of the Tripura High Court on 14 November 2018 and was later transferred to the Patna High Court on 10 November 2019. Serving as Patron-in-Chief of Bihar Legal Services Authority and Chancellor of Chanakya National Law University. On 6th February 2023, he was elevated as a judge of the Honorable Supreme Court of India. Beyond the courtroom, Justice Karol has actively contributed to judicial administration and legal development, participating in national judicial initiatives and committees aimed at improving institutional efficiency and access to justice. Yet, it is through his judgments that we truly witness his lordship's commitment to constitutional values, procedural fairness, and substantive justice. Among his most significant rulings in Bailuru Tippaiah was the State of Karnataka 2025 and Reggie Kumar was the State of Kerala 2025, his lordship engaged deeply with the principles governing capital punishments. While affirming conviction in heinous offenses, the court commuted the death penalty to life imprisonment after carefully weighing mitigating circumstances, reinforcing that sentencing must be individualized and rooted in humane understanding of justice. In Ramcharan vs. Sukhram 2025, his lordship upheld the right of tribal women to an equal share in ancestral property. The court declared that customs excluding women from inheritance must evolve and cannot be allowed to perpetuate discrimination, thereby advancing gender equality. In Amlesh Kumar vs. State of Bihar 2025, his lordship reaffirmed that involuntary narco-analysis tests violate fundamental rights under Articles 23 and 21, safeguarding the right against self-incrimination and personal liberty. In Kailash vs. State of Bihar 2024, his lordship delivered a powerful judgment condemning the disrobing, grievous assault, and public humiliation of women accused of witchcraft, holding that such acts are a blot on the constitutional spirit of equality and dignity. In matters concerning compensation and welfare legislation, His Lordship has adopted a liberal and purposive approach in Sadhana Tomar versus Ashok Kushwaha. He interpreted the term legal representatives broadly under the Motor Vehicles Act to include dependents beyond the immediate family, thereby ensuring equitable compensation. Through these contributions, Justice Karol's jurisprudence embodies a harmonious blend of legal precision, constitutional morality, and a humane approach to adjudication. Sir, your presence here today is a source of immense inspiration for all of us. It is truly a privilege to have you with us, and we are deeply honored by your guidance. We're delighted to welcome Mr. Jayant Mehta, Senior Advocate at the High Court of Delhi, as our distinguished speaker today. Conferred with the rank of Senior Advocate by the Delhi High Court in 2021, Mr. Mehta has established a formidable practice in the field of dispute resolution, earning a Band 2 ranking in the prestigious Chambers and Partners Directory for 2026. His forensic rigor and persuasive advocacy are widely recognized across the legal fraternity. Mr. Mehta has appeared in numerous complex matters before the Delhi High Court and the Supreme Court of India, particularly in the areas of constitutional law, commercial disputes, and arbitration. His ability to dissect intricate legal questions and present them with clarity has earned him the respect of both the bench and the bar. Beyond his courtroom appearances, Mr. Mehta is deeply committed to legal scholarship. He has delivered an incisive analysis of the Bharatiya Nyaya Samhita, examining the evolving legalities of sedition and its interpretation in the contemporary legal landscape. He has also contributed to various legal journals and conferences, writing on subjects ranging from criminal jurisprudence to the law of evidence. His contribution to legal academia extend to mentoring students and young lawyers, and his discourse on evolving nuances of the law reflects a profound commitment to legal education. Mr. Mehta frequently participates as a panelist in national and international seminars, sharing his insights on emerging legal frameworks. A principled advocate with decades of experience, his career stands as a testament to what dedicated and erudite advocacy can achieve. We are truly honored to have him with us today. We're delighted to welcome Mr. Siddharth R. Gupta, who is a graduate of NLIU Bhopal from the batch of 2006 and is currently practicing at the Supreme Court of India, with regular appearances before various high courts across the country. He began his legal career under the guidance of Mr. Vivek K. Tankha, Senior Advocate. Over the years, Mr. Gupta has handled a wide range of matters including real estate, education, taxation, service law, and arbitration. He served as the standing counsel for the High Court of Madhya Pradesh establishment for nearly 4 years. His clientele includes corporates, industries, prominent media groups, and several PSUs. He currently represents RERA, Madhya Pradesh, before the Supreme Court. Mr. Gupta achieved the distinctive feat of representing 9 nationalized PSU banks simultaneously while handling the largest volume of financial and monetary matters in the High Court of Madhya Pradesh. After practicing in the High Court for almost 15 years, he shifted his practice entirely to the Supreme Court in 2022. He is also extensively involved in academic writing for the SEC EBC group. He is the author of a unique summary of all constitutional bench judgments of 2024 delivered by the Supreme Court, as well as annual summaries of landmark constitutional law judgments for the last 3 years. These compilations are widely referred to by law graduates and aspirants preparing for competitive examinations such as judiciary, law clerks, and CLAT PG. Mr. Gupta is also a founding member of the CAN Foundation, a pan-India initiative dedicated to making legal education and the legal profession accessible to financially challenged law students. We are honored to have him with us as our distinguished speaker. We're delighted to welcome Mr. Abhishek Kumar, partner at Singhania and Partners LLP, as our distinguished speaker today. As the head of the firm's infrastructure, arbitration, and insolvency practice, Mr. Kumar has cultivated a career defined by forensic rigor and strategic acumen. He boasts nearly 2 decades of experience and has successfully represented leading infrastructure companies, multinational corporations, and government undertakings before the Supreme Court, High Court, and the National Company Law Tribunal. His practice encompasses complex arbitration, insolvency law, commercial litigation, and contractual dispute. In a significant recent victory, he successfully argued a high-stakes statutory arbitration concerning land acquisition under the National Highways Act, achieving a reduction of an inflated compensation award from 113 crores to approximately 3.70 crores. This outcome underscored the importance of evidence-based assessment in infrastructure disputes. Beyond his courtroom advocacy, Mr. Kumar is a distinguished legal author. He regularly contributes scholarly articles on arbitration and insolvency law, and his publication on the maintainability of arbitration application in insolvency proceedings remain a highly referenced work in the field. His career stands as a testament to the highest standard of legal practice and scholarship. We are truly honored to have him with us today. As a mark of our deepest reverence and respect, we now invite our Honorable Vice Chancellor, Professor Dr. S. Surya Prakash, to extend a warm welcome to the distinguished panelists gracing this dais. I request Honorable Vice Chancellor Sir to present a bouquet, a memento, and a shawl to Honorable Justice Sanjay Karol, a jurist whose judgments speak not merely of law, but of conscience. I request Honorable Vice Chancellor Sir to present a bouquet, a memento, and a shawl to Mr. Jayant Mehta, a legal practitioner of profound insight and quiet distinction. I request our Dean Undergraduate Studies, Professor Dr. Atul Kumar Pandey, to present a bouquet, a memento, and a shawl to Mr. Siddharth R. Gupta, whose expertise adds immense depth to this panel. I request our Dean Postgraduate Studies, Professor Dr. Sanjay Yadav, to present a bouquet, a memento, and a shawl to Mr. Abhishek Kumar, a valued voice in this distinguished gathering. This humble gesture symbolizes the gratitude of an institution that draws its very purpose from the wisdom and integrity of the judiciary. We respectfully acknowledge the presence of His Lordship and that of our revered advocates with a measured round of applause. The session we now embark upon is titled Strengthening India's Arbitration Framework, Revisiting and Reforming the Arbitration and Conciliation Act 1996. 3 decades since its enactment, the Arbitration and Conciliation Act 1996 has served as the foundational statute shaping India's approach to alternative dispute resolution. Over the years, it has undergone significant amendments and judicial interpretation, contributing to the evolution of arbitration jurisprudence in the country. This discussion seeks to examine the existing framework, assess its effectiveness in facilitating efficient dispute resolution, and explore areas where further refinements may be considered. Key themes for deliberation include the balance between party autonomy and judicial intervention, measures to enhance cost effectiveness and timelines, and the role of institutional arbitration in strengthening India's position in the global arbitration landscape. The present panel shall be chaired by Honorable Justice Sanjay Karol, Judge, Supreme Court of India. I now invite our Honorable Vice Chancellor, Professor Dr. S. Surya Prakash, to come up on the dais and kindly share his welcome remarks on the subject of this session, setting the intellectual context for the discussion ahead. Sir, the floor is yours.
Good afternoon to all. Dignitaries on the dais, Honorable Justice Sanjay Karolji, and other eminent advocates, Sri Abhishek Kumarji, Siddharth Gupta, and Sri Jayant Mehta, and my dear students and distinguished faculty members. The program today, the topic is Arbitration and Conciliation Act in India, Time to Revisit Act 1996. So, the act was enacted keeping in view the international obligations for international commercial arbitration as well as the domestic arbitration. And what happened, the title suggests that time to revisit the Act 1996. So, in fact, are there any fallacies? Or India is not a favorite or favorable destination for international commercial arbitration. No one can deny it. Today, even the Indian parties, they look at Singapore, they look at London, or even they look at Hong Kong, but not India. So why in India? We boast that now we are the 5th largest economy. Very soon, we may become the 4th or even the 3rd largest economy by 2047. There is very good economic growth, fastest growing economy. In spite of all these positive factors, why we are lagging behind to attract whether it is investment arbitration or whether it is any other international commercial disputes? Is it necessary to revisit, or as Honorable Justice S.H. Kapadia once said in Balco International case, that consistency is required to attract the investors or to attract the people. When I say people means the commercial or the international companies, corporate. So what happened, I won't take much time, just I would like to flash 1 or 2 points where it is discussed about the party autonomy and other things, liberation. If you remember, there was a lot of turbulence in the international commercial arbitration during the period 2002 to 2012. That is Bhatia International. So where only one word, the courtesy, the Supreme Court of India, in interpreting the last clause of Section 2, this part shall be applicable only to Part 1, because the word only is not there. The courts interpreted that Part 1 may be applicable to Part 2. So Part 2 was meant for international commercial arbitration, and Part 1 was meant for domestic arbitration. And the Honorable Court has said that Part 1 is applicable to Part 2. That means, what are the provisions meant for domestic arbitration, such as Section 7, 9, interior measures, and all these things, they were made applicable to international commercial arbitration. And the position didn't remain the same. And then another bench said that Part 1 is not applicable, just like what happened to the definition of industry. There was a lot of disturbance, there was a lot of turbulence for almost 1 decade. And finally, the matter was settled by 5-judge bench headed by Honorable Justice S.H. Kapadia in Balco International. So between 2002 to 2012, we lost golden opportunity. Instead of stabilizing the law in international commercial arbitration, because of the different interpretations for the same clause, only one word has disturbed. Is it the fault of the draftsman? Because they didn't add the word only. Because the word only is not there, the court said that this clause could be applicable to anywhere. That means this part, first part, was made applicable to Part 2. So, the inconsistency in the interpretation of different clauses. There was Iranian offshore case where the parties' interests could be identified through their communication. Because gone are the days where agreements used to be written by sitting across the table, discussing the each and every clause, and finally reducing the agreement or contract. Nowadays, one party sitting in Iran and another party in Australia, one party. So, through telex, through emails, finally, they conclude. One party thinks that we have concluded the agreement. Other party thinks that the agreement is not yet concluded. That's what the Iranian offshore case. Only on the basis of header of the telex, the court said that, yes, there is an arbitration agreement. And many a times, the court said that even in the case, that is the windmills case, the case generated from the state of Madhya Pradesh only, the court said that unless and until the party sign in the arbitration agreement, no one can be made a party to the arbitration agreement. So the arbitration agreement must be in writing, and the party should have signed. But now the court said that even the party has not agreed to refer their dispute for arbitration, the party could be included as a party to the arbitration dispute. So these many inconsistencies in the interpretation of clauses, the Act is the same since 1996 to 2026. The Act is the same, the clauses are the same, the words are the same, but what makes the change is the interpretation of these words, these clauses. So, should we blame the draftsman and the Act to revisit the Act, or we should revisit the jurisprudence or the decisions of the Honorable High Court and the Supreme Court, particularly the Supreme Court, from time to time, different interpretations, even confusing the academicians. So today what we say, this is the law, tomorrow it won't be the law, it may be overruled. So in such scenario, how could we muster and confidence in the international parties to identify Indian law as the law for their arbitral disputes? So no doubt, we may revisit the clauses, the Act, but also we must thoroughly discuss where there are variations. I don't call it aberrations. Every judge thinks that this is the best interpretation. But when we look at series of judgments, when there is line is not straight in the judgments, when it goes this side and that side, that will make a distress among the parties. Better not to go to Indian law, to choose India as the place of arbitration or Indian institutions. Let us go where the law is consistent, where the awards are less challenged. Few days back, we have an expert from Singapore International Arbitration. I asked him out of anxiety, you have been delivering the awards. How many awards have been challenged in the High Court of the Singapore, and how many awards they were set aside by the court? He took time. Sir, hardly none. Hardly none. But here, the awards passed by the tribunals, the arbitration tribunals, institutions, even ad hoc arbitrations. I do not want to take the names. But they have been set aside. And the awards were delivered by the stalwarts, the persons who has occupied the highest seat of justice. So what we have to look at is the variations and the aberrations and why there is inconsistency. So unless until, as in the Balco, Honorable Justice S.H. Kapadia has stated that law requires consistency. Law means it includes not only the print law, but also the judgment law. With these few words, this is going to be a thought-provoking session. Particularly, we have the experts who have been in this field for the last 2 decades, 3 decades. And this is also a very, very important subject for the students also. Explore, enrich, and get your doubts clarified by the leading jurists. And of course, we have Shri Pankaj Karolji to clarify your doubts. And in these few words, my introductory remarks, I will take leave. Thank you very much.
Thank you so much, sir, for those insightful words. I now invite our esteemed panelists to commence their deliberation. The floor is open for discussion. I now invite Honorable Justice Mr. Sanjay Karol on the dais.
Good afternoon to all of you, my co-panelists on the dais and the audience. I told Mr. Gupta that I'll be digressing from the topic which has been given to me, and I'll be very, very brief. And the purpose is twofold. One, there are a lot of matters which we have to decide on the judicial side, so I would rather refrain myself from expressing my views in this platform. Two, we'll have a more interactive session. And three, I come here as a student because these gentlemen who are going to guide us there would also guide us here, help form an opinion. And see, Professor said that we are the 5th largest economy of the world. In 1996, compared to economies and where we are today and where the other economy is, I would also go to the extent of saying that it has taken almost 56 years from 1940 till 1996 the new act came. And in 1947, two nations were born. And those two nations, India and Pakistan. How did the Arbitration and Conciliation Act, or the Arbitration Act of 1940, work itself? In my considered view, as a student of law, I would say that we were doing very, very well. And suddenly, in the name of opening of economy, something was dumped upon us. And that was the Act of 1996. Nonetheless, the two nations progressed in different directions, also leaps and bounds as far as economy is concerned. Now, if I were to compare the two eras, the pre-96 era and the post-96 era, Professor has just said that, he has not said that, but can I not say this as a student of law? It has resulted into more confusion, uncertainty. Because as we see that right from Renu Sagar, saw pipes, associate builders, Sangyong, Balco, what is it that we have laid down? Patent illegality, public policy, all these are concepts which we have evolved. And the reason is this, that we realize that, or the judges realize that there's something amiss, all is not well, which required correction. The system itself was not serving the purpose or achieving the objects for which it was enacted. Because we realize that this act is foreign to us. And therefore, we came out with evolved these concepts. And the last of this concept, or the latest of this concept, was what we call as the binary principle, or the modification of the award. Maitri. Now, the act was brought in to achieve two objects. One, see that the players, national and international, had a sense of certainty about the law, the time frame, so that they could make investments. After all, people come to make investments, be it at international level or national level. They come to make investments to generate profit, make money. There cannot be any situation of uncertainty. I asked this question to myself, that the principles which we have evolved from 96 till 2025, has it brought some certainty, consistency or not? Now we have the new proposed amendment. Now, would this proposed amendment take care of or address the concerns of all concerned? Is something which we'll have to see in the passage of time. Two things which I must share this. For example, your own state in Madhya Pradesh, you have in government contracts, public works contracts, you have a specialized tribunal. Now, whether that system is workable, has worked well in this state, can be emulated elsewhere or not. Delhi is now experimenting or doing away with the arbitrations in all these commercial contracts. I, for one, I must share this. I was telling my chamber colleague that when I was the Advocate General, I suggested to the government that let us do away with these arbitration clauses in the government contracts, because it was resulting into absolute commercial absurdity, if not anything else. But then the players in the system, the stakeholders had a different say, and it continued to be like that. But we have to take care of only one thing. See that this nation grows if we have to fulfill the aims and objects of the preamble of the Constitution. Then this nation has to grow, the economy of this nation has to grow to bring in social change. And this economy can grow only if there is speed, consistency of thought process and action. I would also say this, that this can come only when Professor Saab said about the Singapore model. Why is it that world over people are now going to Singapore? They have a certainty with regard to the finality of the award. Right or wrong is a totally different matter. Whether we can afford it or not to have it is something which we'll be educated during the course of the session or with the passage of time. But definitely the economy must grow and there has to be certainty. Because if we see the graph of the pendency from 40 till 1996, there are very few matters pertaining or arising out of the Arbitration Act. But post 1996, the surge is up north. And what is the answer? Let us all think about it and come to definite solutions. I would also say this, as was mentioned that part 1 and part 2 of chapter 1 or chapter 2 of the Arbitration Act, should we go back to, as far as domestic arbitrations are concerned or matters pertaining to grassroots level are concerned, should there be arbitrations at all or not? Or should we go back to the Panchayati Raj system of decisions at the grassroots level by the people, for the people, and for themselves? These are my thoughts. I stand to be educated by the eminent panelists here. And I would also say this, Professor Saab, that whatever the deliberations, please do share it with us on paper. Thank you very much.
Thank you, sir, for those inspiring and insightful words. I would now request Mr. Jayant Mehta, Senior Advocate, High Court of Delhi, to kindly address the gathering.
Good afternoon, Honorable Justice Karol. Always a privilege to hear him. Honorable Professor Surya Prakash, my panelists, friends, Mrs. Sanghi, a very, very good afternoon to all of you. Given that we're debating a very serious legal issue here, and given that how inspired and awestruck I am by how simply Justice Karol spoke to you, I have decided to divide my address into 3 parts. An introduction, which I'm going to commence in some time. Then a few issues that I'm going to raise. And the last part is very important. I'm going to be asking questions from you. And those who are invisible from here are going to be answering them. So the more backbencher you are, the more questions you're going to face. So be prepared. Now, the introduction. How many of you have studied the subject of arbitration? Could you just raise your hands, please? Accordingly, one has to pitch. How many of you have studied the subject of Arbitration Act? 1, 2, 3, 4, 5. Yeah, okay. Well, that's not a very encouraging number, is it? Yeah. Okay, so I understand that you haven't studied the subject. So let me begin with a very basic introduction. What do you think of arbitration? And why do we have arbitration? We have courts of law. You're guaranteed by Constitution a right to approach that court. Nobody can take away that right. If not Arbitration Act, you would have certainly studied CPC. If not studied CPC, you would have heard of it. There is a provision in CPC, which is Section 9, and which is your right, any litigant's right for that matter, to approach a court of law for a civil cause. So when you have the facility of a court and a system, and perhaps, at least in theory, the promise of a certainty, why would you want to go for arbitration? Because arbitration is complete antithesis of a court system. It is unstructured. It depends on your consent. It doesn't follow common law as a court would. It follows a very, very different structure. The awards are not precedents. In fact, between the same parties, one award may not bind the next tribunal if they have disputes between them. So why have this uncertain, unstructured monster and fancy it as if it's the next big thing on the horizon? A lot of students come to intern with my office, and when I ask them, what do you want to be? What do you want to do? The first answer that one gets is to become an international arbitration lawyer. That's great. And I hope and pray that all of them become, because we desperately need some very, very good law practitioners on that scene, particularly from our country. But let's understand as to why do we have arbitration at all. Now we realized that the court system, while it has its own merits, you have a judge who sits at 10:30, hears causes, decides according to what the parties instruct him, in the sense that the parties place their case before him and what the law is. But at the same time, one suit does not fit all, right? One suit never fits all. So you have to have flexibility, which also is a part of certainty. Flexibility in resolution of disputes. And how do you build that? While going to the court, I can't say, no, I want my matters to be listed before Justice Karol. I can't. That would be misconduct on my part. But in the realm of arbitration, I have a say, if not a unilateral choice, to choose the judge that I want to appear before. Why? Why should you have that choice? Why should a party have that choice? Because the party may feel that given the context of my contract, someone who has this kind of experience would be well suited to be a judge for my cause. In other words, and Justice Karol would not mind my saying, it is better to go before a known devil than an unknown devil. So, you have the flexibility of a system where two parties to a commercial contract may decide to have their disputes adjudicated by a judge of their choice. Now, please note that I have said a judge of their choice, not of one party's choice. So we are talking about 2 or 3 principles here, which you would have heard of, but now let me iterate them to you. The first principle that we spoke of is called party autonomy. What is party autonomy? That each party has a choice to agree and prescribe for itself a dispute resolution mechanism. And that, my friends, is what we call as arbitration. Party autonomy. I prescribe for myself. I don't have to go to a court of law. Now, party autonomy has several facets. One, of course, is prescription of an agreement inter partes. Second is the choice or a say in choosing who would be the judge in their cause. And it goes on, and as we proceed, I'll keep harking back to the principle of party autonomy and go further from there. But what is most important is that there has to be an agreement between the parties. So that's your first port of call. As a lawyer, is there an agreement between the parties that certainly exhibits their intent of arbitrating? If it does, then the courts have held that their disputes can't, as a matter of obligation, can't go before the court, but they must go before the arbitrator. Now, we have, in the context of the 1996 Act, seen a whole lot of debate on what constitutes an arbitration agreement. Those of you, I saw only a few hands going up when I asked the question as to who has studied Arbitration Act as a subject. Those of you who haven't and who aspire to do so would find Section 7 in the Act, which says what is an arbitration agreement. An arbitration agreement is nothing but a contract. A contract can be formed by a variety of ways, either by a formal document signed by the parties or by exchange of documents, correspondence, and so on. Now, the first question that I will be in the next session, in the next part of my session, I'm going to be asking you is, when we already had the principles of what amounts to a contract contained in the Contract Act, why did the legislature have to define in Section 7 as to what is an arbitration agreement? I'm not going to answer that, but somebody in the back bench is going to answer it. Let them put on their thinking cap immediately with their eyes shut. The next thing that is important is that who would be an arbitrator? Can my cousin, my uncle be an arbitrator? Or not? The law prescribes that the principles of independence and impartiality, that's the ethos, that's the basis of our court structure, applies in equal rigor to arbitration. So you have to have an arbitrator who's independent. And unlike the 1940 Act, which did not have those thresholds in the statute, the 1996 Act has got Section 12, which has been amended to include 12(5), which requires express consent of waiver. 14, 15, schedules 7, 8, 5, 6, 7, 8. So therefore, you have a framework which defines that your chosen judge, the party's chosen judge, has to be independent and impartial. So two principles which are very, very important. So party autonomy, but autonomy doesn't mean that you can choose a judge who's a relative or who's biased or who's non-partisan, or who's partisan, I'm sorry. The next aspect of arbitration that would confound you is, all right, I have decided that I will go for arbitration, and I've decided the manner of choosing the judge. But who decides the rules of the game? How would arbitration be conducted? Now, given that the law allows the parties the choice of choosing arbitration as a mechanism to settle their disputes, the law also promises that the parties can prescribe the rules of their adjudication. That is the procedural rules, not the substantive law, but the procedural rules. And within that, I'm sure as you progress in your law classes, you'll read about lex arbitrae, proper law of contract, and so on and so forth. Those are concepts that would take much longer than just 18 minutes for me to dwell on. So therefore, I'll just leave them to you. Read up. The next aspect that is important in our debate is the manner of challenge of an award, to an award. And that has gone, as Justice Karol was saying, from back and forth, 4 steps forward and 3 steps back. Or what I describe as, and Justice Karol would not mind my saying so, that courts and lawyers alike, like 5 blind men trying to describe an elephant in all preciseness. So therefore, we had the 1940 Act which said the award has to become a rule of court, and the court could rule on it. And it went on to say that unless the parties decide that the tribunal is required to give reasons, the arbitrator could be the Roman emperor to say, I award, I don't award. Rule of thumb. So we have come far from that. And now in the 1996 Act, we have a requirement by the statute that award has to be reasoned. So when it comes to questioning the award, the courts have gone back and forth. We have had from Saw Pipes to Sangyong, from Venture Global to Kaiser. So we've had, and a whole lot can be said about that debate. And now we have Gayatri Balasamy, which says in certain situations the court can modify the award. Each of these are concepts that may sound very alien to you, and you'll be more disinterested in them as you are right now. So coming back to the issue that I feel should be debated in the next part of my session is, do you feel that an award should be allowed to be factually and legally reviewed by the court? And if you do feel that, why do you feel that? And if you don't feel that, why do you don't feel that? Well, we'll debate about it. So the questions now are the second part of my presentation to you. Why do you have in Section 7 a definition of what constitutes an arbitration agreement between the parties? I want one of you to consider and answer it, or more of you. As many of you want to answer it, the better it would be. Because we are here as students, and we are here to participate in this debate, and we would love to hear from you as to what you feel about the topic. The second is, to what extent should the rigidity of the court structure be incorporated procedurally or substantively into the arbitral machinery? Should the law prescribe as to what procedure the arbitration should follow, or should it be left to the parties to decide? Because very importantly, Justice Arun said, and so did your Vice Chancellor, that many parties do not wish to arbitrate in India, and if they have a choice, they would go out. And in fact, I was arguing a matter before the Delhi High Court, and which has now been approved by the Supreme Court also, which holds that two Indian parties can decide to arbitrate abroad. They can, of course, not contract out of Indian law, but they can decide to arbitrate abroad, meaning thereby that they would go out of the Indian court system except for two aspects: an interim measure of protection and enforcement. Should the arbitration law be so flexible as to allow two Indians to arbitrate in a territory other than India? That's a question that I'm asking you guys. Lastly, what should be the ideal position with respect to the court reviewing or not reviewing an arbitral award? So just consider this, and then we'll debate about it. And coming now to the last part of my presentation, which is asking some of the backbenchers for answers to these questions. I let go that, knowing full well that I don't want to embarrass anybody. But I'm happy to answer these questions to you, and I'm happy to debate with anybody who's interested in debating it. That's the whole point of our coming here, spending time with you. So I'll just say that much. And I hope that this debate helps us understand the topic better and gets you interested in this phenomenal subject of arbitration law. And I hope someday some of you would become international commercial law experts, including on Arbitration Act. I tried, but I have not been as lucid or simple as Justice Arun is. And when I was sitting, hearing him in the inaugural session, I was surprised that he cited to you Panchayat, which was shot here in Bhopal. And he spoke to you about Mamla legal hai, and he spoke to you about the suits. So about his simplicity, if I may just end by saying, Dekh raha hai Binod. Thank you.
Thank you, sir, for your words of wisdom. I would now invite Mr. Siddharth R. Gupta to the podium to kindly continue the session.
Hard-pressed. Honorable Mr. Justice Sanjay Karol, Judge Supreme Court of India, respected Professor S. Surya Prakash, Vice Chancellor, NLIU Bhopal. I'm saying abbreviations because I have to cut short. Respected Senior Mr. Jayant Mehta from the Delhi High Court, Mr. Abhishek Kumar from Singhani and Partners, Mr. Aditya Sanghi, learned senior advocate who has traveled all the way from Jabalpur to Bhopal to attend this. my revered faculty members, diligent committed members of the Student Bar Association who are hosting this conclave, all the dear students, a very good afternoon to you. Today's session is a very, very special and distinctive one for me. It is special because I'm sharing the dais with somebody who taught me 2 decades back for 2 consecutive years as a teacher, Professor S. Surya Prakash. And it is distinctive because I've got this honor to share the dais with Honorable Justice Sanjay Karol, who is one of my role models from whom I emulate for the basic virtue of life which I picked from him, that your temperament and thoughts shape your destiny and your future. So coming to the topic today, revisiting and reforming the Arbitration Act 1996, I think it requires a little rectification. Rectification from the corrective approach to the evolutionary approach. The ingenuity and innovation today we require to overhaul the arbitral arbitration regime in India. The respected Vice Chancellor, Honorable Justice Karol, and Mr. Mehta, my learned senior, all echoed the same sentiment, that India is not the hub for international arbitration for trans-border disputes today. The learned Chief Justice of India, the Honorable Chief Justice of India, also last month in Gujarat echoed the same sentiment. I recalled that. And what is it which is lacking, and where do we need to actually mend the ways upon? It definitely does not require a revolution, but it requires evolution. You need to have an exceptional, procedurally refined, defined, and disciplined arbitration regime. That's the first. Then arbitration regime, like my learned senior pointed out, which is imbibed with integrity, impartiality, independence, and autonomy, all these 4 traits. You have to look forward towards all this. And a lot has been done, especially the 2015 and the 16 amendments which added the 5th, 6th, and 7th schedules prescribing standards for arbitrators. So I'll be touching upon 3 aspects today. I've been asked to keep it short because we are nearing lunch, and all of you must be waiting for that. So I'll quickly touch upon the 3 aspects which, in my opinion, require immediate and urgent attention. The first aspect is an amendment which incorporates the regime of, or establishing arbitration appellate tribunals over the award passed by the arbitrator. I'll refer to them as AATs as an abbreviation. The second is solving this seat venue conundrum confusion which courts have been grappling with for the last 20 years. You need to have a legislative provision specifically for that. The third aspect I'll be touching upon is strengthening the framework of emergency tribunal, emergency awards in India, instead of the court-driven statutory provisions asking you to approach the court again and again. So, these are the 3 issues I'll quickly mention. The first is idea of establishment of the AATs, arbitration appellate tribunals. Definitely, an amendment of this nature is a most welcome step, desirable step, because be it United States, UK, or the Mecca of arbitration, the Singapore, US, it has been existing for the last 3 decades. There is an appeal against the award which is internalized. And I'll explain what internalized means. And it's working quite practically, feasibly, viably so far. In US also, there is an internalized appeal mechanism which is optional, available to the parties to get the award tested by a superior tribunal. AAT, I am referring to that. Singapore is also considering, like I said. The Supreme Court of India also recently, in the judgment of Centro Trade versus Hindustan Copper, echoed this sentiment of having, even in India, of having an authority within the agreement, within the arbitration agreement, testing the correctness of the award. agreed to by the parties. So this will be a paradigm shift from a single-tier award to a multi-tier arbitration within the same agreement. It has multiple advantages. The first and foremost is that you have a body sitting over the award which tests, checks, and rectifies the error, which may otherwise go unnoticed, may be overlooked by the regular civil courts which are testing awards or deciding challenge under Section 34. That's the primary advantage. The other advantage is, especially in high-stake arbitrations which may have international overtones, is that precision, accuracy, and domain expertise is required even for testing an award. So when you have a multi-tiered arbitration, internalized multi-tier arbitration, the same set of domain expertise, same set of domain experts are testing the award. You may have limited remedy or may have no remedy for testing the award thereafter, but this is something which is desirable. Now, what is Section 34 today in the Arbitration Act? Section 34 today is essentially a setting aside mechanism. It's not an appeal. The setting aside mechanism rests on the foundational belief that the award is final, sacrosanct, because it's a creation of the contract agreed to between the parties, like my senior Mr. Mehta pointed out, party autonomy, a facet of party autonomy. So it should not be interfered. But at the same time, the party must have, if the party wants to have the award tested on merits, as such there is no remedy under the Indian regime, except Section 34. And the amendment which is proposed to the Parliament, the 2024 draft bill, amendment bill, also proposes insertion of Section 34A after Section 34, providing this optional feature of double ATs to be instituted or included within the arbitration agreement. However, there is a grave lacuna there, the proposed provision. There is no timeline prescription for the double AT to decide the challenge to the award. Like I gave examples of US and UK, they have time prescriptions of 2 months, 3 months for the challenge to the award to be decided. Even Section 34(6) today provides for a 90 days or 180 days window for the award, the challenge to be decided. However, 34A does not have any such timeline. So that is, if that is brought into reality, that is something which has to be necessarily taken care of or catered to. Now coming to my next aspect, the resolving the seat and venue conundrum. Section 20 of the Arbitration Act says, place of arbitration shall be the determining factor for ascertaining which will be the governing law. The seat and venue conundrum has been engaging the attention of courts, highly contentious one for the last 3 decades. Whether the place, the venue where the arbitration takes place physically shall be the place which will determine the law governing the arbitration, or the legal seat where the agreement is executed will determine the applicable law, or where the cause of action arose. The courts have been, like my senior said, Honorable Justice Arun also said, 4 steps forward, 3 steps backward. And these are issues which are engaging the court at the threshold stage without letting the parties actually litigate on the merits. They are litigating at the threshold on all these aspects. So seat and venue conundrum is something which needs urgent resolution. And I'll give the example of, say, English laws. The Section 6A of the English Act puts a default rule that wherever parties have not agreed for any law governing the agreement, Section 6A says that by default, it will be the law of the seat. That is where the arbitration agreement has been agreed to, or the seat has been agreed to of the arbitration. Something of this nature needs to be incorporated expressly in the Arbitration Act also, in the Indian Act. Article 16 of the London Court of International Arbitration also on the same lines. The last point is emergency arbitration, EA and ET, emergency tribunal, emergency arbitration. Now, what is actually emergency arbitration? Emergency arbitration is for interim measures, interim orders. You may litigate on the substantive dispute at a later stage. However, to preserve the subject matter of the dispute, to prevent it from disintegrating, you need to have orders from some competent authority. Right now, we have Section 9 in the Arbitration Act, where we have to approach the civil court, flag the urgency, and then get some interim orders in your favor. But so far, 3 decades have shown that that has not worked very meaningfully in terms of the spirit, soul, and spirit of the enactment. You have Section 17, where the arbitral tribunal has powers to pass any interim orders, but that is post-constitution of the arbitral tribunal. So this vacuum, before when the parties conceive of going for a dispute resolution, and from the point until the point the arbitral tribunal is considered, there is an absolute vacuum. This is where this constitution of emergency, ET and EA, the concept of ET and EA comes in. A tribunal is constituted only for the limited purpose of passing interim orders. The Supreme Court, in the landmark judgment of Amazon versus Future Group, acknowledged this concept and affirmed and held that such EA awards passed by ETs are enforceable. They can be enforced on the Indian soil. The 2 benches of Delhi High Court, my learned senior would be aware, one is Ashwini Minda, has also affirmed the view of the Supreme Court, holding that if in a foreign seated ET an award is passed of an interim nature, it will have binding value, enforceable value in India. But a divergent view has been taken by the different bench, Raffles Design. So we are at the crossroads. This is a gray area which needs some kind of resolution, and that is possible only by a legislative intervention, a formal recognition of the regime of ET and EA in India. Coming back to the draft bill, again, which has been proposed to the Parliament, there is a provision, Section 9A, which is proposed to be added after Section 9 to the Arbitration Act. This 9A proposes to introduce this whole concept of ET and EA, both in the context of domestic as well as international arbitrations. Now again, there's a problem with this. The problem is, you have Section 9A, you have Section 9A also. You have Section 9 and then you have Section 9A also, if it sees the light of the day. Which of the two will the party resort to? 9A definitely has to be given primacy and precedence over Section 9, and rather Section 9 has to be done away with. It should be obliterated from the textbook. But the problem here is that not enough homework is being done when amendments are being proposed, and that's the reason, like Honorable Justice Karol pointed out, that 1940 till 1996 we were doing happily, we were doing very fine. But 1996, along with the enactment, ushered in also a barrage of disputes. So Section 9A, ET and EA, it must not be half-baked. It must also substitute the civil court remedy of the interim measures available to the parties. Otherwise, the parties will always be at deadlock as to which of the two should be preferred, which is better, defeating the very purpose, converting the situation bad to worse. So these are my thoughts, some of the thoughts. I wanted to speak more, but for some other day. I'm really grateful to you, all of you, for listening to me. Grateful to my professor, Professor S. Surya Prakash, for considering me worthy for this panel. And last but not the least, the entire team of SBA, who has been running pillar to post for the last 15 days to make this event happen and happen successfully. Thank you, everybody. Jai Hind, Jai Bharat.
Thank you, sir, for your in-depth insight. I now invite Mr. Abhishek Kumar to the podium to kindly share his perspective with us.
Good afternoon, everybody. Honorable Mr. Justice Sanjay Karol, learned VC Saab, and my learned seniors who have really taken a lot of pain to explain the various kinds of concepts which led to enactment of Arbitration and Conciliation Act, the purpose of the act, and why this act is important when we have the regular courts with us. Since it's already lunchtime, I may not take much time, but there are few aspects which I would like to highlight. It's been a long journey since the Act of 1940 to 1996, and then amendments which were brought in 1996 Act in the year 2015 and 2019. Till then, lot of water has already flown. When this Act of 1996 was incorporated, there were 3 separate acts which were existing. There was a separate Foreign Awards Act also. So all those acts were merged and this 1996 Act was enacted. If you see the corporate development of India, after 1996, lots of multinationals and corporates came to India. And probably after that, the disputes increased like anything. And therefore, with the experiences, certain amendments were felt necessary. And in 2015, major amendments were brought into the Act. Some of them I'll just discuss. Like we already had Section 9 of the Act, which spoke about providing interim protection to a party either before commencement of arbitration, during the arbitration, and even after conclusion of the arbitral proceedings. But a similar provision was provided under Section 17 for the arbitral tribunal. However, it was a very restricted provision. So in 2015, that provision was made almost equivalent to Section 9. Similarly, in Section 34, the provision was such that once a petition challenging an award was filed and court admitted it, it was presumed that there is a stay on the enforcement of the award. That confusion was cleared by amending Section 36 of the Arbitration and Conciliation Act in 2015, that there will not be an automatic stay, but one has to make an application before the court, and court has the power to grant conditional stay. Now, after that, even in 2019, some amendment has been brought that if an arbitral award has been achieved through fraud, then that's a ground for challenging the award. So I will not, I'll basically discuss about the amendments which may be brought under Section 34, that Section 34 really needs a revisit or not. Now, if we see what is the purpose of Section 34, it was not just merely challenging the award. Ultimately, there has to be a finality to the issue, that an arbitral award has come, which has rightly or wrongly decided some issue. One has a remedy to approach the court challenging that award. But what is the meaning of challenging the award? It's not just setting aside of the award. The issue needs to be closed. Unfortunately, the language of Section 34 is such which does not provide parties a complete remedy. It's a half-baked remedy. Courts have the power to set aside the award, but not modify the award exactly. This issue, it really seems interesting. From the point when an arbitral tribunal is constituted, up to the time the challenge procedure has come to an end, where parties go to single judge, then they go in appeal before the DB, and then before Supreme Court. If the award is set aside, the only remedy available to the aggrieved party is to reinitiate the arbitration, which is completely frustrating. So, the remedy should be where courts should be allowed to modify the award. Unfortunately, that power is not available to the courts. Now, recently, one judgment has come from the full bench of Honorable Supreme Court of India, where in certain cases, that power of amendment has been provided. But what are those cases? Those are very restricted ones. The court has held in Gayatri Balasamy judgment, the court has held that in case you can separate out the valid and invalid part of the award, then that invalid part can be set aside, modified. The court can also modify a typographical, computational, or some clerical error in the award. Then the court can also modify the award of future interest. But does that really solve the problem? If we see, there are, I'll give you one small example, one matter which I had done and I faced this difficulty. The parties had a contract. In contract, there was a specific provision provided that in case of failure to make any payment, the aggrieved party shall be entitled to interest at a particular rate. Now, the award was passed in ignorance of that clause. The award was challenged. Court under section 34 noticed that yes, there is a contractual clause and interest ought to have been paid as per this clause. They set aside the award. What next? The party which was liable to pay that interest still didn't pay that. And as per the law, which is here as on date, the aggrieved party had only one option, reinitiate the arbitration. So we again invoked the arbitration only for the purpose of that interest. The other side had even challenged their judgment in section 37 and their challenge was rejected. They did not choose to file another appeal in Supreme Court. So that issue became final. But even in that case, we had to reinitiate the arbitration just for the purpose of that interest, which was already settled by the single judge, by the division bench. That arbitral proceeding again took some time. And the strange part is that they challenged that award and a notice has been issued by the court. So, despite there being a contract, the party who is entitled to receive the interest is fighting even today, after 7-8 years. So, I feel that, it is important that that final remedy, that the court's hand should be strengthened to provide that final remedy to the aggrieved parties. A court which can say that this interpretation is incorrect, or there was a contractual clause providing some right to a party, which arbitrator has ignored and set aside the award. The same court can also say that this is the correct provision and this is the correct amount which the aggrieved party is entitled to. So that the power to write that last line, that is not available as on date. So I feel it's very important that that amendment is brought in section 34 so that parties are not left remediless. Besides, I'll discuss one or two more issues. Okay. There is another case I would like to discuss. As per the Arbitration Act, unilateral appointments of an arbitrator by one party, that is not permissible. Earlier it was, then there are few judgments, TRF, Perkins, where Supreme Court clarified that one party who has the unilateral power to appoint an arbitrator, they cannot do so. And if at all that happens, then an award obtained through such arbitrator will be liable to be set aside. Now, there was an interesting case. There was a government department in their contract, there was a provision that they would be appointing the arbitrator. They appointed the arbitrator. The arbitration proceedings continued, an award came. In section 34, obviously the award was passed against the government department. They challenged the award on the ground that the appointment of arbitrator was unilateral. The same arbitrator which they had appointed. Unfortunately, that award was set aside on this ground. And it was upheld up to Supreme Court of India. So, I think while this is correct that there is a specific provision provided under section 12(5) which talks about express consent of parties in writing if at all one party is appointing the arbitrator. There should be an amendment in that section also that the party's conduct has also to be kept in mind. And in 34, that in these circumstances, award will not be set aside. Obviously, the legislature has to ponder over these issues. We can only express our views as the students of law. Now, there is an amendment bill, 2024, Arbitration and Conciliation Amendment Bill. Certain amendments have been proposed there, and some of them are really very good. That if at all, one of the important amendments is that the earlier case which I was discussing, that if the party is to reinitiate the arbitration, whether everything will be opened or there would be some sanctity of the proceedings which has already taken place for, say, 2 years, 3 years. So the proposed bill provides that the parties will be bound by the arbitral record which were filed in the previous arbitration. And the tribunal will be deciding only such issues which have been set aside by the court, not all the issues. Besides, the tribunal, the fresh tribunal disputes, not all the disputes are arbitrable. And an arbitral tribunal decides such issue, then that will be a ground for setting aside of the award. Then that will be a ground for setting aside of the award. So I feel that the act is really very small, but considering its implications, certain provisions, despite the fact that major amendments have been proposed in the new bill, Section 34 has not been, is not being modified effectively, which may be considered by the legislature, and we may ponder over it that in what manner it can be more effective. So with this, I'll just close my today's, I won't say the lecture, whatever it was, the presentation, and it was really a privilege and honor to be standing here and speaking before a good set of students. I would like to tell the backbenchers also that just don't feel worried. I also used to be a backbencher only. I never used to sit in the front row. If I can stand here and speak, you all will speak after becoming a lawyer. That's the beauty of this profession. Thank you. Thank you, everybody.
Thank you so much, sir, for your insightful words. We have heard illuminating perspectives from our distinguished panel. I now invite the audience to participate. Due to a paucity of time, we shall only be taking 3 questions from the audience. If you have a query, please raise your hand. Kindly wait for the microphone, state your name and institution, and direct your question to the specific panelist you wish to address. Let us ensure our questions reflect the rigor and respect that have defined this session. The floor is now open.
Good afternoon, sir. Good afternoon, distinguished panelists. My question specifically would be to Abhishek, sir.
Sir, as we were discussing about the Gayatri Balaswamy judgment, I have my own disagreements. I believe the panel would be kind enough to entertain the same. I believe that the disagreement that I have on the same is regarding the power to modify. While, as you have explicitly mentioned that the same power has not been mentioned in section 34 of the Act, I do believe that the same was derived from the power to set aside the award, and the lesser power to modify was derived from the same, as per my limited reading of the same provision of the same judgment. So my question is that, as per the judgment clearly mentioned that the power to modify includes, but it does not restricts the power. So here my question again comes back to the judicial activism and as per as judicial restraint as well, because I was having a similar discussion with the same representative from the SIAC, as Vice Chancellor Sir mentioned, and this was our discussion that he also mentioned that there's very less of predictiveness that is in the Indian scenario, because as per the judgment clearly mentioned that the power to modify includes, but there is no restriction. So how would you like to see it in the amended section 34, if you would like to see it there?
Very bad question. See, no, I was just kidding. See, that's court's interpretation in the judgment that, power to modify includes. But if you see how the law has traveled, in section 34, it is not specified. A judgment came sometime in 2005-06, McDermott, by the Honorable Supreme Court of India. In that judgment, it was probably Justice S.B. Sinha's judgment. It was clarified in that judgment for the first time, clearly, that, a court sitting under section 34 is only entitled to either accept the award or reject the award, leaving the parties to begin the arbitration afresh if they want. So it was clarified at that point of time only. So the power of modification was never available. Now, since it was actually leading to practical difficulties, which was considered by the Honorable Supreme Court in the matter of Gayatri Balaswamy. If you read the concluding para of the judgment, there have been a lot of discussion on various aspects, so I will not get into that because we are short on time. But if you see the concluding para, they have clearly specified 3 cases under which an award can be modified. First case is when the invalid portion can be severed from the valid portion. Second, that the court can modify the award to the extent it requires correction of a computational error or typographical error. Third point, court has the power to modify the post-award interest. Now, when I spoke about the final remedy, which is not being covered under this judgment. Because, as I said, today courts can say that this power is, this part of the award is invalid. But they cannot say that this is what the valid portion is, this is what is valid, and this is how the rights of the parties have to be dealt with. That part is missing. Even court specified that the modification of the award can be done only for the post-award interest. Why? If, I'll give you one case which I'm doing recently, there is a specific agreement on the part of interest. Court has, the tribunal has taken a view that, I'll award this much only. The agreed rate is 14%. Tribunal says, I'll give 10% only, till the date of passing of award, which is pre-award period. Despite this being a wrong, a court under section 34 cannot correct it, because neither this power is available in 34, nor as per this judgment also, Gayatri Balaswamy, because it only talks about post-award interest. So that's the issue which I was discussing. I hope I answered your question.
Due to a paucity of time, we will not be taking any more questions. With that, we come to the conclusion of session 1 for today. I deeply thank all our esteemed panelists for their enriching insight towards the topic. Your discourse continues to have a deep impact on everyone present. All dignitaries are requested to proceed to the guest house for lunch. The audience is requested to leave after our esteemed dignitaries have departed. The lunch for the participants and their faculties has been arranged outside the convention. We shall regroup together for panel discussion 2 to be held post-lunch at 2:30 p.m. Thank you so much.
A very good afternoon to our esteemed guests and participants. We shall be beginning with panel 2 shortly, so I request you to kindly settle down and put your phones on silent mode. Thank you so much. request everyone to, at the outset, please welcome our panelists with a huge round of applause. A very good afternoon to our esteemed dignitaries, respected faculty members, and discerning participants. I welcome you back after the lunch recess, and it is my humble honor to now begin the second discussion session of the second edition of the NLIU-SBA Law Conclave. Please allow me to first introduce the distinguished panel for this session. We are deeply honored to welcome Honorable Justice M.I. Arun as our first panelist. His Lordship was born in Mysuru in 1970 and graduated from the National Law School of India University, Bengaluru, in 1993 and enrolled as an advocate in the very same year. After practicing under distinguished seniors, His Lordship began independent practice in 1996, representing universities, state government undertakings, and serving as a central government senior panel counsel. His Lordship was elevated as an additional judge of the Karnataka High Court on 7 January 2020 and became a permanent judge on 25 September 2021. Beyond the courtroom, His Lordship actively contributes to judicial administration, consistently emphasizing procedural fairness and adherence to natural justice, particularly in commercial and tax law. It is through His Lordship's judgments that we truly witness his commitment to constitutional fidelity, procedural discipline, and pragmatic justice. Among His Lordship's most significant rulings are Sri Padampati Enterprises versus Commercial Tax Officer, a 2023 ruling in which His Lordship set aside an order for confiscation of goods under Section 130 of the CGST Act, holding that an opportunity of being heard is not merely a formality, but a substantive right indeed. A written reply does not substitute for a meaningful hearing when harsh measures are contemplated. Another very important ruling is Messrs. Vigneshwara Transport Company versus Additional Commissioner of Central Tax, a 2024 ruling, wherein His Lordship directed a refund of Rs 50 lakhs to a transport company, declaring that investigation, search, seizure, and arrest under the GST framework can only be done by the proper officer as defined. His Lordship's judgments consistently affirm that procedural justice and natural justice are substantive requirements, particularly when it comes to taxation and commercial matters. Sir, your presence here today is a source of immense inspiration for all of us. Thank you so much, sir. It is truly a privilege to have you with us, and we are deeply honored by your presence. We are also delighted to welcome Mr. Ajay Bagaria, Senior Advocate at the High Court of Madhya Pradesh, as a distinguished speaker today. Designated as a Senior Advocate by the Madhya Pradesh High Court, Sir has built a formidable career marked by rigorous legal reasoning and principled advocacy. Sir's practice spans constitutional law, civil litigation, arbitration, and criminal law, and he has appeared before the Madhya Pradesh High Court, the Supreme Court of India, and various tribunals. As a partner at Bagaria and Associates in Indore, Sir has earned a reputation as one of the most respectful voices at the Madhya Pradesh Bar. And in a recent high-profile matter, Sir represented the petitioners in the Indore water contamination case before the Madhya Pradesh High Court and successfully urged the court to demand accountability from the state government on how the contamination became so severe as to prove fatal and to ensure safe custody of all relevant records amid concerns of document manipulation. Sir also appeared for Jungli Pictures in the case concerning the release of the film Haq, persuading the court that the film was a fictional adaptation and securing dismissal of the petition seeking a stay on its release. Sir, we are truly honored to have you with us today. We are also pleased to welcome Mr. Sankalp Kochar as a distinguished speaker with us today. A seasoned legal professional with nearly 2 decades of practice, Sir has built a strong and respected reputation through sustained dedication, sharp legal reasoning, and meticulous preparation. Sir's work reflects a deep command of legal principles coupled with the discipline and clarity that define an exceptional advocate. Since beginning his independent practice in May 2007, Sir has developed extensive experience in complex legal matters before the High Court of Madhya Pradesh. His professional journey reflects consistent breadth of exposure and a sustained commitment to excellence in advocacy. And over the years, Sir has been associated with significant legal responsibilities and has contributed extremely meaningfully to matters which require precision, judgment, and thorough analysis. So, your presence adds an immense academic and professional value to our gathering, and we look forward to your valuable insights. For major Indian and global businesses. Sir's practice extends to advising a diverse client. Sir's practice extends to advising a diverse clientele, including multinational corporations, public sector lenders, government ministries, and private equity funds. He has handled high-stake matters involving critical sectors, including infrastructure, energy, finance, insolvency, white-collar crime, and environmental law. It is practitioners like Sir who remind us that law, at its very best, is both a science as well as an art. Sir, we are truly honored to have you with us today. As a mark of our deepest reverence and respect, I now invite our Honorable Vice Chancellor, Sir, Professor Dr. S. Suryaprakash, on the stage to kindly extend a very warm welcome with a bouquet, a memento, and a shawl to Honorable Justice M.I. Arun. His Lordship is the judge whose fairness and clarity have indeed enriched the very jurisprudence of this nation. And we are so humbly grateful to you, sir. Thank you so much, sir. I now request Professor Dr. Sanjay Yadav, sir, the Dean Postgraduate at National Law Institute, University, Bhopal, to kindly present a token of our gratitude to Mr. Ajay Bagaria. Thank you so much for your presence today, sir. Thank you, sir. I now request Professor Dr. Atul Kumar Pandey, the Dean Undergraduate Studies at National Law Institute, University, Bhopal, to kindly come up on the stage and present a token of our appreciation to Mr. Sankalp Kochar. Thank you so much for being here today, sir. I also request Mr. Manish Bahuguna, the Controller of Examination at National Law Institute, University, Bhopal, to kindly come up on the stage to present a bouquet, a memento, and a shawl to Mr. George Verghese. We extend a humble gratitude to all of our guests today who have spared their time and been here to illuminate the young minds of this country. Now we proceed to the session that we are here today for. The session is titled Strengthening the Grassroots of Indian Judiciary, Blending Success to Justice with Technology in the 21st Century. This discussion examines the theoretical and practical when it comes to marginalized litigants. The objective of this session is to critically explore how innovation can be harnessed without compromising the principles of inclusivity and procedural fairness. This scholarly conversation will seek to balance the promise of technological advancement with the foundational values of an accessible and people-centric judiciary. The present panel shall be chaired by Honorable Justice M.I. Arun, Judge at the High Court of Karnataka. And I now invite our esteemed panelists to please commence their deliberations. The floor is now all yours.
So it'll be, am I loud and clear to all of you guys sitting here? Right. So let's begin by you, Lord Honorable Justice Shri M.I. Arun, because you come from Bangalore, you've practiced, I just asked you and he says he's practiced in Bangalore before he was elevated to the Karnataka High Court. And Bangalore, as we all know, is to a large extent and quite rightly also the technology hub of India, and it still continues to be. Give us whatever you think about this subject, as strengthening the grassroots of judiciary, blending it with technology. Let's have your open and honest views about it.
See, whenever we speak about strengthening the grassroots of Indian judiciary, three things come to the mind. Number one is accessibility. Number two is affordability. Number three is quick justice. So whatever technology that is available today has to be in tune with these three aspects. In my opinion, technology can definitely play a major role in enhancing all the three. And if administered properly, if facilities are created by the state, then we need not worry about exclusion of any section of the society from utilizing the same. Say, for example, in courts in Karnataka, already we have got, the associations themselves are having these facilities for video conference, which are provided to advocates who cannot afford it by themselves. This is one small example I'm giving. Now, before jumping into how to utilize technology, I think it will not be out of place to mention a few words about strengthening of the grassroots of Indian judiciary. This is because, first, to deliver substantial justice, the court of first instance has to be robust, accessible, and cheap, affordable, in other words. Now, it requires a proper population to judge ratio, which is unfortunately not there in India. Second, that means to say that, firstly, that means to say that we need to have more number of judges at lower judiciary, and the vacancies are required to be filled up in time. And these judges should be well equipped with constant
You can take my mic.
No,
while I work on it.
With constant training and updation. Now here technology will play a major role, because when we all started our practice, at least when I started my practice, the co-panelists are pretty young. We had to get into the library, research through AR manual. AR manual used to be the first book that we used to harp on. We used to take out the sections, then go to the reporters, then pull out the relevant case law. Now at the tip of your finger, you'll get everything. That is the advantage that has happened over here. So legal research is one thing that has become very easy. This can be done both by advocates as well as judges. Having said that, there is a possibility that with the AI advancing so rapidly, recently we had an instance where imaginary presidents were cited before trial courts in Bangalore and judgments were delivered based on that. And I'm told inquiry is initiated right now. There is a possibility that a wrong case law, I mean a non-existing case law can be cited before the trial court. It's a possibility. So this we need to be careful of when we are relying overtly on...
How do you, as a common man's perceptions, how do you actually, so as a lawyer, all three of us, all four of us in fact belong to that fraternity. But let's say for an individual, I mean, how does one distinguish? How do you do the sifting as a judge? I'm asking you very honestly. How do you do the sifting? That this is something which is coming from AI and this is something which seems to be done with a thorough little bit of homework also being done.
Personally, I have never been faced with that particular problem so far, because whatever advocates that I encounter in High Court, there are more responsible. Normally nobody resorts to that kind of a practice over there. But yes, in the trial court there is a possibility that someone might do so. So we need to think over actually how to overcome this particular thing. Or once it is cited, it has to be cross-verified with the database by the judges so that it will help. It will help. If you cross-verify it, you will know whether it exists or not.
Doesn't exist.
Because citation is something that is very essential. So any case law that is shown before the court, there will be citations over there. So that should not be a problem.
Shouldn't be a problem. Before I come to you, George, because you come from now Calcutta and Hyderabad, let me ask Sankalp one more thing, because both Sankalp and I come from the state of Madhya Pradesh, where fortunately you've got a very good development of this e-court process. We have quite a state-of-the-art e-filing process, which is very much in place. We also have payment of court fees by on this thing, and then again there are copies of the orders available. So we got a pretty much in the VC, video conferencing is also pretty much updated in our state. But getting back to what His Lordship was saying, Sankalp, now three things which His Lordship very rightly mentioned. He says access, affordability and expeditious disposal, if I'm right. That's the three phrases which you particularly, keeping these three phases as the kasoti, if you can call it, as the touchstone. How do you feel that technology can be an help in all three facets?
Good afternoon, everyone. It's a very good question in terms of how the entire issue is framed today. The word is grassroots. The grassroots for me would be starting from tehsils. We're talking about district judiciary or the higher judiciary. I think technology has to start from the grassroots, that's the tehsil. Now we have something in Madhya Pradesh which has come up, which is called cyber tehsil, which has got to do with everything right from making an application. The moment you purchase a particular piece of land, the moment you purchase it, your sale deed itself becomes an application for mutation, and other things automatically come and an application is filed, and this is what is cyber tehsil. Now sir was talking about three things. One is accessibility. Now the first thing we have to ask, and that is across board, is the person who's the last person standing in the queue, whether this technology is available and accessible to that person who's the last person in the chain. The answer right now is outstanding and no. The reason being, though everyone now would have a smartphone with them, they don't have the access, right? I'll just cite three examples of technology. One is Singapore, second is Estonia, and third is United Kingdom. Now, as far as Singapore is concerned, what they do is that they have an automated system even before any litigation starts or somebody has a problem. They have an automated system the moment you put in a particular issue in that particular application, you have the entire flow chart as to how you have to move. That's the Singapore model. The second model is the Estonia model, which is regarding once you put in a particular information in that system, in the government system, it is available for all the branches of that is the executive, the legislature and the judiciary. That means the moment your information is there out in the public, it can be utilized for any other purpose, meaning thereby that you're cutting short your entire procedure, right from dispute resolution or accessibility to any other public platform. And the third is the UK system, where now people are not actually going to courts and they have these automated systems for all these genuine small causes cases where on the basis of these applications they're being decided. Now there is a catch to this, and I'll just conclude on that particular aspect. So I was talking about AI and artificial judgments being used at the tehsil or the district level. Supreme Court in recent 2 cases, and I'll just cite them, I was just going through them as well. Now, it happened in the Supreme Court. There was a SLP which was drafted and filed, and Justice Nagaratna came across that. She actually read the entire brief. And after reading that entire brief, she actually made up her mind and eventually came to know that it was a fictitious citation. That was the case of Gumandi Usha Rani versus Malika Arjun. This is 2026, it's reported judgment now, where a fabricated legal content was cited in the Supreme Court. So, and there's another case which happened where Justice Vikram Nath actually openly said that while AI can aid the judiciary, it cannot replace judges. And he said that in Heart and Soul Entertainment versus Deepak Bhari, there also fictitious citations and a particular piece was quoted which did not even exist in that judgment. So I think this, the elephant in the room needs to be addressed, and that elephant in the room is AI, or for that matter, any technology is a very good servant, but a very bad master. Meaning thereby that you can take aid of whatever you want to as technology or artificial intelligence or whatever you want to, but be it a law school, you cannot replace professors. In courtrooms, you cannot replace lawyers. And for justice delivery system, you cannot replace judges. Meaning thereby, the human face or the human touch to justice delivery system has to be there in place no matter how much technology or artificial intelligence we bring in. Therefore, whatever technology we're bringing in, be it for the grassroots or be it at the apex court, be it at the tehsil level, be it at any level we're talking about, it has to be an assistant, an arbiter, but cannot be the master. That is what I think about the issue. Thank you.
Well said, Sankalp, and good to know that the future of the lawyers is not endangered by bringing in this technology. It's good to hear that. As a practicing lawyer, I was actually a bit threatened by the onset of this technology, and particularly more so because someone like me coming from a different generation, the generation of his lordship, we are sort of, I call myself technologically handicapped because even to switch on a laptop, I have to tell my colleagues and my juniors, please do it for me. Forget about joining in line and making submissions. George, will I come back to you on this one valid point which is made by Sankalp. He used particularly this expression very rightly. He said, the last person in the chain. And again, he's very right in pointing out that when you begin at the grassroots level of judiciary, it's not about the Supreme Court and the Honorable High Court, it's more about the people in the village and the taluka and the gram. So how do you think that this entire system, this technology, we can ensure it percolates down to that level? How do we do that? Until we are unable to do that, how do we sort of cope up with this? Because expeditious justice, as His Lordship just said, unless this is accepted as a part of expeditious system of justice, I mean, it doesn't work. What are your views on it?
Yeah, that's an interesting question. I don't think anything is going to happen quickly. As we know, India is a country that moves slowly. Our systems